Okay, good afternoon. Thank you for being here. This is Judiciary Non-Civil Subcommittee. Before we start, I wanted to recognize Judge Eddie Barker. Thank you. Thank you for being here. Good. Okay, so Chairman Smith.
And I'd be remiss if I didn't recognize one of my district attorneys, Herb Cranford from the Coweta Judicial Circuit. Just wanted to take a moment and thank you, Herb, for being with us. And also, Mr. Bill Finch, solicitor from Forsyth County, my friend. Good to see you as well.
Okay, thank you, Chairman. Okay, the first bill we're going to take up is Chairman Beach, Senate Bill 31. Hi, Senator.
Well, good. Hey, good to see you.
Good to see you.
Madam Chair, thank you for hearing this bill. I bring before you, Madam Chair and committee members, Senate Bill 31. And I was in the Appropriations Committee meeting, and the Attorney General presented, and he said he was having to go to different DAs that would not enforce the law, and it was coming out of his budget. So that's how I came up with this idea. And then I really got to thinking about it, and every one of us here is elected by our citizens in our district. And we come down to the Capitol, and we introduce and vote on legislation that will make it better for our citizens. And, you know, passing a bill is not easy, nor should it be. And as I said, bills are introduced, they go through the committee process, they get vetted, then they go from the Senate to the House or the House to the Senate and goes through the same process, and the governor signs the bill. And then it's codified into law. We are the lawmakers. Therefore, I bring Senate Bill 31 before you. Our Attorney General is having to step in and prosecute cases that certain DAs refuse to prosecute. In one case, a DA has a list of crimes that she will not prosecute. I guess that's good for criminals so they know what they can avoid prosecution from. But the purpose of this bill is very simple. If the district attorney must go and enforce laws in a county where the DA won't enforce laws that we have passed, then that DA's office needs to reimburse the Attorney General for actual cost and expenses, lodging, food, and hotel and billable hours. Now, there is one caveat to it. The Attorney General has to get a guilty plea or a guilty verdict, and then he must submit his expenses to the Superior Court of that county within 15 days for reimbursement. So there is some checks on it. The Superior Court judge has the final say on whether these expenses are warranted or not. So that's basically what this does. I just don't think the Attorney General should have to incur expenses for doing the job of a DA that doesn't want to enforce our laws that we've passed. And that's the crux of this bill. And I would ask you for your support. And if you have any questions, I'd be happy to entertain questions. Thank you.
Thank you, Chairman. Any questions from the committee? We have one. Is that Representative Miller?
Thank you, Madam Chair. Good afternoon, Mr. Chairman.
Good afternoon.
Always good to see you. Just a couple questions about this bill. When the Attorney General, let me back up. What role does prosecutorial discretion play in how your bill, if passed, I guess what I'm trying to figure out is if I, as a prosecutor, assess a case and determine that there is insufficient evidence to proceed forward on it, and another prosecutor, say the Attorney General, disagrees with my assessment, and that Attorney General who has concurrent jurisdiction over it decides to move forward, why then should the prosecutor who has the ability to exercise that discretion pay someone or pay out of their budget a prosecutor who just viewed the facts and the evidence differently? Does that make sense?
Yeah,
that was a
does make
long
sense.
question.
And look, I know you're a former DA's office and worked in a DA's office, and so you know more about this than I do. I just would tell you when these crimes that are like gang crimes and different crimes that the Attorney General said he is going to prosecute in different areas of the state because the DAs won't do it. I think the real kicker is he's got a guilty plea or a guilty verdict to get reimbursed. So he must think those cases are important, or the Attorney General wouldn't be going to him. One example is Athens-Clarke County. He's going to Athens-Clarke County a lot to prosecute some really violent crimes that is not being prosecuted. And I just think the DA should do their job. And if they get hurt in their budget, maybe it'll wake them up to where they'll do their job, and the Attorney General won't have to step in.
May I follow up, Madam Chair?
Yes.
So are the cases that, and you use Athens-Clarke County as an example, are the cases that the Attorney General has gone into Athens-Clarke County to prosecute cases that the DA specifically declined to prosecute?
Yes,
Okay.
is what the Attorney General has told me.
Okay.
And let me be very clear, the Attorney General did not ask me to do this. I did this when I was in my budget hearings and heard that he was spending X amount of dollars going around the state to prosecute cases that really he shouldn't be prosecuting. The DAs should be doing that. And I just, the light bulb went off. I said, well, he should be reimbursed. I even asked him that question. I said, are you being reimbursed? He said, no, it's coming out of my budget. And I just don't think that's fair. So that's why I wrote this bill.
Thank you. Leader Efstration.
Thank you, Madam Chair, and to the sponsor, Senator, thank you for bringing the bill and the opportunity to ask questions today. I'm sorry I didn't get with you before, but isn't it true, it's my understanding the Attorney General only has limited potential crimes to prosecute that are authorized under Georgia law. So last year I carried a bill authorizing the AG to prosecute criminal gang offenses in local jurisdictions. There's also AG's empowered to prosecute anti-human trafficking crimes and things like that. But there's limited offenses
Correct.
for which the AG can come in and prosecute. So we're really talking about a limited number of offenses potentially where we have by general law authorized the AG to prosecute locally. Is that correct?
Correct. And I would also say that he will not be reimbursed when a DA asks him to come in and recuses them. I think that happened in DeKalb County where District Attorney Sherry Boston asked him to come in and do it, and it was because she did not want to prosecute that case for some reason and ask. So the Attorney General would not be reimbursed on that. This is just on those cases that you talked about, human trafficking and so on, that he does have jurisdiction, and he goes in and does that. And again, the Superior Court judge gets to look at all the receipts to make sure nothing's been embellished, if you will, and he's being reimbursed just for his actual expenses.
Thank you. Any other questions from the committee? All right. Chairman, do you have any witnesses today
No,
to
ma'am.
testify? Okay. We have one person signed up. So Carter from ACCG. And I'm going to limit the time just because we have several bills that I think will take a while. So I'm going to give you 3 minutes.
That's fine.
Thank you. And if you can state your name and where you're from.
Perfect. Well, thank you, Madam Chair and fellow committee members. My name is Gabriel Carter. I'm with ACCG. We represent all 159 counties across the state of Georgia. I would first like to thank the author for being willing to have this conversation with me about the bill, and also being willing to hear out our concerns. And I hope we can work together to find a compromise here in this committee. ACCG has a few concerns with this bill that I hope the committee will take into consideration. First, counties don't have the authority to dictate cases that district attorneys decide to prosecute or not to prosecute. DAs are elected officials. Counties have no authority to tell them to prosecute a case or tell them not to prosecute a case. So we fear that counties and local taxpayers are going to be penalized for something that they have no ability to control. Secondly, the county does not have the ability to control how the Attorney General decides to prosecute. With this lack of local accountability, the Attorney General has no incentive to be mindful of the court-related costs that they incur that will have to be reimbursed by the county. And kind of following up on that point, the third concern we have is since the Attorney General has to obtain a guilty plea or guilty verdict in order to qualify for reimbursement, This would cause the AG's office to spend an inordinate amount of expenses on an expert witness, for example, to make sure that they get a guilty verdict or plea, kind of that extra incentive to make sure you win, since the only way to get that reimbursement is to have a guilty verdict. So, for example, not to say that they would do this or not to attack the character of the Attorney General, but, for instance, there's nothing in this bill that prevents the Attorney General's office from paying $100,000, $150,000 to bring in an expert witness from Arizona, California, somewhere on the West Coast, and counties will be responsible for reimbursing that. Whereas a local district attorney may be a little bit more mindful of the costs since they have more local accountability. And lastly, this bill does not indicate that the county will be included in the arbitration process between the DA's office and the Attorney General's office, even though it's being seen before a Superior Court judge. We believe that if counties are going to have to pay this reimbursement, again, DAs aren't going to have to pay, it's going to be the county that has to pay this. We believe the county should at least be able to be at the seat. I have a seat at the table when this arbitration process is taking place. So in line with these concerns, we have a proposed solution. We have an amendment. I'm not sure if it was included in your folders, but one of the amendments that we had was, instead of taking the reimbursement from the county or the local government, making sure that that reimbursement would come from the line item in the state budget that's dedicated to district attorneys, if that is the intent of this bill. Again, we believe that this bill is not, we believe the intent of this bill is to have some kind of effect on district attorneys, but we believe that county governments, and local taxpayers are the only one facing the real burden of this bill. Thank you again for the opportunity to speak and share our concerns, and we hope that you take them into consideration. And I'll stay for any questions if Madam Chair allows.
Great, thank you. That was right at 3 minutes. So.
Perfect. Thank
Thank you. You did very good.
I practiced a couple times.
You have one question, Representative Miller.
Thank you. Can you just say what your amendment, your proposed amendment was one more time?
Yes, I can read it verbatim. So the proposed amendment, I'll just read the whole thing really quickly. When a district attorney fails to prosecute a criminal case or cases, the Attorney General shall be authorized to prosecute such criminal case or case when the Attorney General has concurrent authority to prosecute such criminal cases. But this is the important part. The Department of Law shall be entitled to reimbursement of the actual costs and expenses incurred in the prosecution of such criminal case or cases from the state funds made available to the district attorney's office that failed to prosecute such criminal case or cases.
Okay, so it is in essence just saying that, thank you, that the funds would come from state funds allocated to the district attorney as opposed to county funds?
Yeah, so there's a line item in the state budget that is, it's not the line item for the prosecuting attorney's council. There's a different line item that goes straight to district attorney. So if the will of the committee is for that for the AG's office to get reimbursed, we would hope that that would come from the state instead of the local government.
Okay, thank you.
Thank you.
Thank you. Any other questions? That is it. Thank you for coming and testifying. Yes, if you, yes, yes, sure.
Madam Chair, I'm against that amendment. That amendment was tried in our committee in the Senate. It doesn't make sense to me to have the state pay the state. I mean, it's just, it doesn't make sense. We might as well have the Attorney General just incur the cost because it's a state budget. So the purpose of this is to make those DAs accountable and have them pay to where they'll start prosecuting these cases. If it's state money, they'll just continue to not enforce our law. So I'm against that and would ask that you consider that it really doesn't make common sense. Thank you.
Okay, Chairman, if you can stay for a minute, I think we have 2 questions for you real quick on the amendment, if we can.
Okay.
Representative Roberts? Okay. Representative Miller?
Thank you. Mr. Chairman, on the amendment, what would your response to the argument be that essentially, let's say it's Fulton County, I live in Fulton County, I pay Fulton County taxes, I also pay state taxes, that we're sort of paying twice because we are already paying for an attorney general with our tax dollars, we are paying for a district attorney with our tax dollars, and now we're sort of double paying. The attorney general is, a salaried state employee. What would your response to that be?
Well, my response is if that DA was doing he or she's job, that just Attorney General would not have to go and get a hotel room and have lodging and food and expenses. And that's all I'm trying to do is get him made whole. And that's all that is. And I don't want to make him whole with state dollars out of our budget when the DA in a county's not doing their job. I think it should come from the county funds, and that would hopefully encourage DAs to prosecute these cases that he's available to prosecute: human trafficking, gang violence, that type stuff.
Thank you.
And that's what I'm doing.
Understood.
Representative Roberts, is it on the amendment? Okay, that's fine.
So I'm just curious, did you discuss this bill with the Superior Court judges as far as the 15-day turnaround?
I did not. That came as an amendment by our Senate committee because they wanted to make sure that to kind of address the $150,000 witness and so on, so that it just didn't go out of control. And I agreed with that, and that was from our minority leader in the on the committee, and I agreed with that. I said, you're right. The whole idea is just to be reimbursed for expenses, not witnesses and so on.
I understand
And
that,
I think
but
that's where the Superior Court judge kind of has a check and balance. And so I thought it was actually a good idea.
So we all heard the state of the judiciary and the backlog issues, and I can tell you as a lawyer, 15 days is a quick turnaround for any hearing in the state of Georgia. And so I guess that's my concern.
No, he doesn't have to hear it in 15 days. It must be submitted within 15 days. So if the Attorney General gets a guilty plea or a guilty verdict, within 15 days of the filing of the motion, he has to, well, I guess it is. Yeah, the judge would have to hold a hearing. Yeah.
That's what I'm saying.
And if you want to change that, because the way it was meant to be was that the DA had to submit his the Attorney General had to have his submitted expenses within 15 days.
Yeah, I'm just concerned that when they're already backlogged to hold a fees hearing in 15 days, to me is putting an undue burden when they have probably more important cases to be handling.
What was meant to be on that was that the Attorney General had 15 days after a guilty verdict or guilty plea to submit his expenses of lodging and food and billable hours and such.
Okay, well, I may make an amendment at that.
Okay.
So, Chairman, on that note, so line 19 essentially is the Attorney General has to file a motion within 15 days. And starting with line 21, which is subsection B, relates to holding a hearing on that motion. So is it are you looking for a specific day that the judge should hold, or should that entire paragraph be, is it unnecessary? What are your thoughts on that?
I would be happy to strike that 15 days, because I understand what you're saying. Because up in lines 19, it does say that the Attorney General has 15 days to submit. So I would be willing to change that to whatever. I mean, you're a lawyer. I'm not. We can change that or strike that.
Okay, I'm gonna. Chairman, do you have somewhere else to go? Can we?
No, I'm fine.
Okay.
I would be willing to strike line 21 completely and just the judge shall, and start at 22. The judge shall hold a hearing to determine whether this district attorney failed, and not really have a date certain. If that's good with you, Representative Roberts, just strike line 21 completely.
Chairman Smith.
Thank you, Chairman Beach. Good to see you. Glad to have you with us. So, in reviewing this and talking to several members of the subcommittee here real quickly, the judge could either assess for these costs to be reimbursed by the district attorney, who gets a state line item appropriation, or they could assess it against the county.
Correct.
Under this. So it gives the judge that discretion. That's your intent?
Correct.
Okay, it wasn't your intent to have the county pay for this.
Well, no, time out. I don't want the state reimbursing the state.
But they still could.
And that's what that
potentially.
amendment does, and
Okay.
I'm adamantly against that. I would rather, I just don't see that makes any common sense to have the state repay the state
But the judge
because
could,
the county's not doing their job.
But the judge could order that the district attorney's office pay that, and that could from the state money.
I guess that could happen because that Superior Court judge will have the final ruling on how the expenses are paid.
Okay, thank you.
Any other questions? Okay. Any discussion? Well, Chairman Gunter.
Let me just share a little bit of my experience to help the committee. As DA, I had 6 different budgets. I had the state budget, I had a circuit budget, and then I had a budget for each county that I dealt with. So that's where the funds came from. The state budget that came down was all salary. It paid for people that worked in my office. The county budgets covered local expenses. If I had an office in that county, it paid for their utilities, phone, all that kind of stuff, copier. The circuit budget paid for the employees of the circuit that worked in my office, investigator, people like that. So that's how those budgets work. And in reading your bill, the judge would assess the cost, but I'm not real clear on where that would come from, which pot that I would reach into to cover that.
Yeah.
I don't know if you can comment on that.
I'll be honest with you. I didn't know you had 6 buckets of different monies.
That's 'cause I had
Yeah,
counties. If I
yeah.
had more than that, I would have more. But
So I'm not sure. I'm just trying to get the Attorney General to be made whole when he has to go and do someone's job that they're not doing,
and I agree
basically.
with that.
So,
If they're gonna have to come in and do that, they should be reimbursed.
right.
But your intention is that it comes from county funds.
From county funds, yes.
Okay, thank you, Judge. Chairman, I think we're going to go ahead and do this as a hearing only for now, it's just so
Okay.
that we can go ahead and have those discussions.
All right.
And we can kind of hash out the language that will go towards the intent of
Okay.
what you're trying to do here. So,
And again, I would be willing to strike line 21 completely.
thank you.
Okay?
Okay,
Thank you very much.
thank you so much. All right, the next bill is Senate Pro Tem Kennedy. I thought I saw him. Yes, yes. Okay. We're going to hear Senate Bill 272. Senator Pro Tem, thank you for coming.
Thank you for having me.
Yes. And you are here for Senate Bill 272, correct?
Yes, Madam Chair.
Okay. Whenever you're ready.
Okay, thank you. I'm going to keep my water bottle close. I'm sorry, woke up a little nasally this morning. Thank you, Madam Chair and members of the committee. I appreciate the chance to present to you Senate Bill 272, which is really a follow-up to last year's Senate Bill 441. The intent behind the bill was to update the state's inadequate system for transmitting criminal history records. This bill builds off last year's by improving on the work of the Criminal Case Data Exchange Board and placing the board with the Administrative Office of Courts and the Judicial Council. The subcommittee may recall the news articles from last year describing the millions of criminal charges that had been adjudicated or dropped, but without a final disposition being filed with the state's Crime Information Center. It was estimated that 7 million criminal charges were without a final disposition, and 5.4 million of those had languished for years. Having open charges on the file negatively impacts the ability of judges and criminal justice agencies to have accurate criminal histories and that data, and it further impacts our citizens' ability to get jobs, educational opportunities, and housing. Last year's bill spurred many in our criminal justice agencies and clerk's office across the state to look at the process and then try to improve on how these records and this data is handled. And I appreciate the current Criminal Case Data Exchange Board's work, and especially Pete Scandalakis for chairing the board. So what does the bill do? Well, it moves the Criminal Case Data Exchange Board from the Council of Superior Court Clerks to the Administrative Office of the Courts, which is within the Judicial Council. The board is currently working on uniform standards for transmitting criminal history data, such as final dispositions that will apply statewide to DAs, solicitors, court clerks, and our court system. It also gives authority to our district administrative judges to assist all classes of courts within their district with implementing the uniform standards that the board creates. Current law provides for 10 judicial districts comprising of several circuits, from which one Superior Court judge is elected by the other judges to help with the various administrative tasks. The bill also empowers several councils associated with our court system to assist in training and the adoption of uniform standards for criminal records transmissions. The board has promulgated uniform standards addressing timely filing requirements for clerks and prosecutors, and is continuing to work through the multitude of agencies that have had a hand in the criminal justice system. In closing, my comments would be that the issue of incomplete criminal history data should be a major concern for our state, and it has been an issue that even the federal government identified as a problem due to incomplete data being available nationwide. Last year, findings that millions of criminal charges are lying dormant without final dispositions filed by the various criminal justice agencies and court clerks is the root cause for incomplete data. Finding out the source of the issue is difficult, admittedly. It could be technology shortfalls, it could be staffing challenges, it could be a lack of coordination between local agencies, but regardless, the Criminal Case Data Exchange Board is charged with figuring these issues out, and we want to further support the board's work by placing them in a more appropriate judicial agency. Thank you, Madam Chair.
Great, thank you. Any questions from the committee? You have no questions, Senator.
Thank you. I appreciate, Madam Chair, thanks for the hospitality, and appreciate the committee's consideration of the bill.
Good, thank you. All right, any discussion by the committee? Judge Gunter, do you want to say, I know you had a House bill that was similar. You can say, yeah, sure.
I did, and there are some slight differences in wording, but the intent is the same. So I support this bill. And I think it's a good bill.
Thank you, Judge.
Madam Chair, may I just
Sure.
answer that? And thank you, Chairman Gunner. And I'm aware of some changes that have been made, and I think they're good changes and support those changes in the current form of the bill as y'all have perfected it.
Okay. And Representative Byrd?
Thank you very much. Was there a committee that was just done like 7 months ago, well, under the clerk of courts? Because I know that Representative Gunter's bill was HB 450, was it not correct? And you were establishing this new board, and was it not the clerk of courts handed that over about 7 months ago? And I could be mistaken in having my bills confused, so I apologize.
I'm assuming, Representative Byrd, you're asking Judge Gunter?
No, well, I'm
Chairman
trying to
Gunter, or-
figure out if this is fairly close to what Representative Gunter's bill was. So for your bill, is it my understanding that the clerk of courts has this information now? Is that correct or not?
Madam Chair, may I get the assistance of my counsel on that?
Yes, that's fine.
James Beal, General Counsel for the Pro Tem. I appreciate the question, Representative. I think what you're describing is the Criminal Case Data Exchange Board as it stands now, which is within the Council of Superior Court Clerks. And so this bill, so to answer your question, yes, it's the same, but this bill is moving that from the Council of Superior Court Clerks to the Administrative Office of the Courts.
And I understand that, but that was established like 7 months ago, was it not?
It was established last session.
Yeah.
Yes, ma'am.
Okay. And explain to me why we want to move that from where it is now.
The thinking
Please.
is that this has become it's become clear through the work of the board that this is a much larger than a clerk's issue or one issue within the judiciary. However, it is a major judicial issue, and so this is sort of a more appropriate place, we think, given all the different criminal justice agencies within the judiciary that the board, the membership on the board entails.
Thank you.
Yes, ma'am.
Okay, thank you. What is the will of the committee? I'll take up any motions, if any, at this time.
Motion do pass.
Okay, all in favor of passing this Senate Bill 272, say aye. Aye. All those who oppose, say aye. Okay, it passes. Thank you, Senator.
Thank you, Madam Chair, and thank you to the committee.
All right. Hi. Yes. We're going to take a quick break. Oh. All right, the next bill we're going to hear is Senate Bill 92, Senate Majority Whip Robertson. Thank you for coming.
Yes, ma'am. Thank you, Madam Chair, for the invitation. I do appreciate it. As always, Madam Chair and committee members, I'm honored to carry a non-controversial piece of legislation. It is. And Madam Chair, just to make sure I'm reading off of SB 92 CSFA, and this is the what has become known as the Prosecuting Attorneys Qualifications Commission in the version that I'm reading from. And to expedite the opportunity to be questioned, I think we have all become very familiar with this legislation. I know that Representative Gullett carried a similar piece of legislation on the House side, and I think he was successful in getting the legislation through and through multiple hearings and was able to explain. I will discuss, I think, without having looked at the latest version of Representative Gullett's legislation, I think the primary differences between SB 92 and what he carries is where the appointments come from for those who would serve on the panels involved in the creation of this mechanism, and where ours comes from the governor's office. I believe that Representative Gullett's came from within the judiciary, and so. I think in order, again, to expedite anything, and I know that the vetting that's being done, and I know that Chairman Smith has still got some of his staff looking at other portions of this legislation and working with the the governor's office, I would be happy to go ahead and open up and start asking questions about this bill that I think we're all extremely familiar with, unless the chair would like for me to walk through each section.
If you can just, and I know you mentioned the makeup of the commission.
Yes, ma'am.
Are there any other differences between this and Representative Gullett's?
No, ma'am, not really. One thing that I really focused on once we got up here, and I do want to point out the history of this legislation started approximately 3 years ago, and what really drew me into the vortex of this legislation is the fact that part of my district covers the Chattahoochee Circuit, which part of that is Columbus and Muskogee County. And just a few years back, a district attorney was elected into the Chattahoochee Circuit, and probably a year and a half or 2 years in office, it was required that he resign. He pled guilty to some prosecutorial misconduct and was sentenced to spend a little time in the Georgia Department of Corrections. And this was due to prosecutorial misconduct. It was not due to any collateral issue or, any issue within outside of his responsibilities as a prosecutor. And so, speaking to Representative Gullett, he brought up some issues around that time of some solicitor generals that there have been some concerns with. So he and I sat down, had conversations with Ledge Counsel, had conversations with some of our friends throughout the district attorney community, listened to some of our friends from PAC and other places, and just for the chair's understanding, I spent 31 years in law enforcement in Columbus and Muskogee County, and had a very close working relationship with the judiciary there and multiple prosecuting attorneys. So I had a very clear understanding of the responsibilities required when the arresting agency presents a case to the district attorney for the ADA's review, the investigator's review, and everything of any Title 16 that we presented before them, and then leaving the ultimate decision up to the district attorney whether to move forward. And what we were realizing is that there were blanket decisions being made either based on particular types of charges or politics, if you will. And knowing that the only individuals that suffer from that are crime victims and the citizens and taxpayers, we felt that it was time to establish what we had all became very familiar with, which is something similar to the JQC. That in the circuits I had worked in, I had seen on multiple occasions where the JQC would have to come in based on a complaint, do an investigation, and judges would either be exonerated of the allegations, and if they were substantiated, then the judges would either resign or retire because of misconduct that was verified by the JQC. And we know that there was the same kind of oversight within the law enforcement side of the criminal justice system. Georgia decertifies more law enforcement officers per capita than any state in the United States based on unprofessional conduct. And so the only gap that we found in looking through this after being exposed to what we dealt with the prosecutor in Muskogee and the prosecutor that Representative Gullett was familiar with, the hole in the system that was exposed, that there was no oversight over the prosecuting attorneys, which the district attorneys and solicitor generals. So we started working on that. And as of today, we have approximately 50% of the district attorneys in Georgia who support the legislation. We've met with them. We've talked through the different changes. And some of those changes, if you'll notice, you would start on line 50, where it talks about the 5 members of the commission's investigative panel. If you notice, the first one would be an attorney with prosecutorial experience. The second would be an attorney with at least 5 years of service as an assistant DA or an assistant solicitor general. The third one would be, 2 practicing attorneys shall be appointed by the Speaker of the House of Representatives. Each shall serve 4 terms. Everything we did along here was we wanted to have peer groups looking at peer groups. So the original legislation had 1 appointee as a citizen, and while that felt good, we did realize that in the investigative process, having somebody on that committee that might be determined to be a political appointee without having experience, a law degree, and experience as a prosecutor in any of the courts, we thought would be counterproductive. And then you also see on line 74 where we discuss the hearing panel, and that again goes to 1 elected district attorney. Go down to line B, and section B, and it's 1 elected district attorney or elected solicitor general. And then I think the real teeth in it's on line 82, where it talks about a former judge of the Superior Court or Court of Appeals. And I think what we've done is we have built a good structure that builds confidence in the citizens back into the prosecutorial side and takes out the politics, if you will, as much as we possibly can from this extremely important position within our criminal justice system that in many cases determines the freedom of the citizens that find themselves engaged in a very intimidating process. And a lot of the prosecutors that we spoke with that did not have a problem with it, and the reason they didn't have a problem with it is because they were very confident in the way that they did their their job and felt that they did it according to the statutes that you find in Georgia law that dictate the responsibilities of district attorneys and solicitor generals. And so with that, Madam Chair, I will be happy to submit to any questions or inquisitions that the committee feels led to offer.
Thank you. Any questions from the committee? Representative Miller.
Thank you, Madam Chair. Thank you, Senator, for your presentation.
Thank you.
I do have some questions in full transparency. I oppose the version of this that passed the House. And so you mentioned specifically your county, I guess Muskogee, and some difficulties with the prosecutor down there.
Yes, ma'am.
And you also mentioned that that prosecutor was himself prosecuted and removed from office
Yes,
as a
ma'am.
result of those things. And I guess what we have heard are anecdotes about prosecutors who have been removed or prosecuted based on misconduct. So I guess my question is, if we already have mechanisms in place that are more streamlined, meaning that the Attorney General could, for example, investigate allegations against a prosecutor, determine that the prosecutor violated their oath of office or other things, indict them, which would give the governor the ability to suspend them, why do you think we need a commission of however many folks that are appointed by various partisans to do what we already can do in a more streamlined way?
Well, and I think I would disagree with the more streamlined way. The prosecutor that eventually went to prison in Muskogee County, basically his first 2 years in office, he absolutely terrorized crime victims. He attempted to manipulate testimony of law enforcement. And my phone, for one, because of my background, I was busy many times on my phone asking, what do we do? Because there is no mechanism. They understood, the average citizen understands what they can do when they felt that they've been mistreated by a law enforcement officer. To some degree, when working with an attorney, they are educated on what the structure is if they feel that the judge is outside the lines and doing something inappropriate. But with the prosecutor, the citizens just didn't have anything. I received audio recordings of phone calls between this prosecutor there and crime victims' families, where he was pressuring them to do a certain thing, and if not, then he would not present the case to the grand jury for an indictment or for a true bill. And so, and it's not just Muskogee County. We had the same thing when we had a young gentleman out on the coast who was killed while running through a neighborhood. And once we started looking at the prosecutor who allowed that incident to percolate over there way beyond what it should have done, then we started looking at the history of that prosecutor and realized that misconduct at that point was absolutely not the first time that there had been prosecutorial misconduct when that prosecutor was in office. And going through this process, individuals have brought up other ideas or ways that the prosecutors could be dealt with. We've talked about impeachment, and we talked about what a cumbersome responsibility that would be for someone to have to come here and to hand the House of Representatives the responsibility of holding a trial and determining whether there was misconduct or not, and then sending it over to the Senate when we're here for a limited amount of time at the taxpayers' expense to do our jobs, when we can find a much more efficient way. We had some people that recommended recall. And if you start looking at the overbearing responsibilities of running a recall campaign, all the way to the point of if you're raising money as a citizen in your citizens group to recall somebody, you're held to the same standards as anybody in this room is who runs for office. You have to register and qualify with the with those responsible for maintaining or ensuring that we maintain our ethics and fundraising and everything else. There is no simple process at this time for a citizen or a law enforcement officer or anyone else in the courts, an attorney even so, to address prosecutorial misconduct under the current system the way it's established. And a simple response in many of these cases is if we put our Superior Court judges, if we put our state court judges, and we put those others that sit on the bench and carry such immense power, if we put them under the microscope of the JQC, I do not see putting prosecuting attorneys, the 50 that exist here in the state of Georgia, under some level of scrutiny that has a high bar for somebody to actually file a complaint and get the process moving. It's not just somebody who doesn't like them. It's not somebody who doesn't like the fact that their son or daughter was sentenced to prison after being adjudicated guilty of a crime. This is actual prosecutorial misconduct. And I just felt that looking at the multiple cases, we also had the case here in Fulton County where the previous district attorney, after a couple of incidences, recklessly went after members of our law enforcement community and disregarded all prosecutorial policies and procedures of the past. And the men and women who were impacted by this had no recourse at that time because everybody was looking around trying to determine whose responsibility it was to rein in this rogue prosecutor. And we just felt this would be the best vehicle to do that with.
Okay. Thank you. So a couple things. You said a lot there.
It's my short answer. Yes, ma'am.
So as it relates to the Fulton, I'll start where you left off. As it relates to the Fulton County District Attorney, shortly after making that prosecutorial decision, he was ousted by the voters. Is that accurate?
Yes, ma'am. The timing was perfect.
Well, so I guess back to my first question: how much will this prosecutorial oversight commission cost taxpayers, and approximately how many elected district attorneys and solicitors will be under its purview?
My understanding is that when the fiscal note was determined in the proper chamber, I think it was around $1.4 million to establish it, and it would bring in under this. Our intention is to bring in the 50 district attorneys and the currently elected solicitor generals here in the state of Georgia.
Okay, so, and I don't know that number. I'm sure someone in here knows it. It's probably under 200 people, I would imagine. Is that fair to say?
I would think that would be close. Yes, ma'am.
Okay, and the JQC, does it cost a similar amount of money?
I'm not exactly sure.
Are you aware how many judges across the state the JQC supervises?
Absolutely. No, ma'am, I don't.
Okay. Do you know, are you familiar with the process of investigating a JQC complaint?
I've been on the outside looking in of the investigations of JQC complaints, and I think a lot of times those are based on exactly what the complaint is. Sometimes it's complacency. I watched one where a judge was disciplined because basically he had case files sitting in the windows that should have been in the process and being adjudicated, and then there were others where the judge's ability to do the job was hampered by an addiction or something of that nature.
Would you agree, based on your observation, that the JQC process isn't always very streamlined and it can take years to adjudicate a complaint against a judge? For example, we had a judge in Atlanta, a city of Atlanta judge, who I will not name for our purposes, but there were complaints about this judge's conduct that arose in, say, 2016 or 17. Charges from the JQC came 2 years later, and those complaints were not adjudicated until many years after the original complaints. I guess I'm struggling to understand why adding layers of state bureaucracy on top of things we already have in place based on a model that is not necessarily the most efficient, but it does what it does for that purpose. Why is it that you think this prosecutorial oversight commission will be better, faster, and more streamlined than all of the things that we already have in place? Because every single wayward prosecutor that you have mentioned has been dealt with by mechanisms that we already have in place in
Yes,
law.
ma'am. The JQC investigations that I witnessed were all very streamlined and very efficient and timely. I can't think of one that was not completely wrapped up within 12 months. The ones that I witnessed, dealing with Superior Court judges and lower ranking judges. And as far as the ones I've mentioned being eventually solved, however that may have been solved, whether it was through handcuffs or elections, I think that our responsibility, and I know the responsibility that I felt was within the criminal justice system, was to try to be as efficient and quick as possible to decrease the amount of damage done to the citizens who are involved in the criminal justice system, which, again, I point out is an extremely fragile and precarious system that easily manipulated or mistreated leads to injustice. And injustice is not acceptable in the law enforcement community nor in the judicial community. And so it certainly should not, prosecutors should not be held to a different standard than law enforcement officers are or state and Superior Court judges are. So that was my reasoning. And the JQC, as I've witnessed, and I know Mr. Skandalakis is in the room from PAC, and he's witnessed probably more than anybody in the room. I've always seen it in most cases where I've seen, every time I've seen it, very efficient and effective. Thank you, ma'am.
Representative Roberts.
Thank you, Madam Chair. Hello, Senator. I guess I heard you say that you want to take the politics out of this process. So I'm wondering how that's possible when the people appointing the investigative panels and people who are going to be making the decisions are all political people. And it could be one day that Democrats are in charge. So I wouldn't want it, one way or the other. But how is that taking it out of politics when those are partisan people making those decisions?
Well, the reason that I don't feel is, and I don't look at it as a Democrat or Republican governor, I look at it as the executive branch making those appointments as far as that goes. And it's exactly like you said, Representative Roberts, is that it is, it could be a Democrat or a Republican. I think where the rubber hits the road is the qualifications of the individuals appointed to the commission that carries the most weight, because these are peers. And I think what you will find in most cases, especially with judges who are nonpartisan, and many attorneys that I have dealt with, Title 16, Title 40, and Title 17, all the other laws, they are not members of any political party. And in the room, as we discuss the law, case law, the Constitution, and everything, we tend not to find a lot of politics there. But for it to be an efficient system and for it to follow along a lot of the customs that we currently follow when it comes to appointments of commissions. And I know over on the Senate side, when we get a list of appointments to the JQC, those appointments are being made by some of those same individuals that you're concerned about as far as the governor's appointments to JQC.
Well, I'm just confused because you only mentioned the executive branch, which we can argue whether that's partisan or not, but it's also the Speaker of the House, the Lieutenant Governor, so those are partisan positions, obviously.
It's part of the yes, ma'am. And I guess that's to be clear, all three branches are involved in this process, which I think whether we like the politics or not, and believe me, I'm one of those individuals that goes about my community and tries to convince people that I'm not a politician. I'm just a deputy sheriff that ran for office. But I think balance is necessary in here. And I think the reality is one day our lieutenant governor could be a Democrat, our Speaker of the House could be a Republican, and our governor could be one of either party. And they still have the responsibility of selecting individuals and put on this this commission that meet the qualifications to be on the commission. It's not a local party leader. It's not somebody who may have, just ran their campaigns or anything like that. These are men and women with law degrees and experience as prosecutors or as judges. And as a career law enforcement officer, I can tell you I never witnessed a lot of politics in the courtroom. I really didn't.
So there was a bill that passed out of the House.
Yes, ma'am.
And full disclosure, I opposed it as well because I just don't think we need this extra layer of government. Are you opposed to the Supreme Court being the ones that establish the investigative panel?
Well, I received information early on that the Supreme Court had visited down here and did not want to be a part of it. And also, I think if the Supreme Court appoints the individuals, if certain charges are determined during the investigation, I'm sure we wouldn't run into a problem with recusal at some point. If a case were to be appealed up to a certain level, the treatment of a prosecutor, and that was my concern. I think the separation is the important thing when it comes to trying to create a fair and balanced process. And I think having judicial making appointments that may one day end up in their courtroom could be a problem.
Okay, one last question, if you'll indulge me, Madam Chair. So, under your bill, can a voter in DeKalb County file a complaint against a DA in Bullock County because they don't like the way they're prosecuting cases?
Well, ma'am, I think anybody can file a complaint against anybody, and the panel looks at it and substantiates the complaint or doesn't substantiate the complaint. I think there has to be evidence there of actual misconduct. And so, I mean, theoretically, yes, ma'am, they could.
Okay. It just feels like that this is a way to subvert the will of the voters who elected that DA and put that DA through a complaint process. And so I made requested an amendment to the other bill that it be limited to a voter in that jurisdiction or a victim of a crime that occurred in that jurisdiction. And my amendment was not accepted because I felt like that was an appropriate level of standing for these complaints. It's the people who are most involved in that community who've seen more of what that DA or Solicitor General has done, and they voted for that person. But I think they're more than capable of determining at the level of what you say you're targeting, which is, pretty major misconduct.
Yes, ma'am.
I think that we can assume that they're pretty good at looking at those facts as well.
Yes, ma'am. Well, this is the first I'm aware of your amendment, and I guess my initial concern would be, my wife and I spend quite a bit of time up here in Atlanta, and it is certainly not in not in Harris County where I live or in the Chattahoochee Circuit. But should I be accused of violating the law here, and if I felt that I was being targeted, mistreated, or my constitutional rights were intentionally being violated by a district attorney, I think for the fact that I do not vote in this district, that I could not file a complaint, even though I was not the victim of a crime either, I think that I understand that anytime we create something new, there's always some concern, but I think a lot of times the hypotheticals that we worry about never happen. Because the system it's not a simple system that because I'm sure I get a lot of the same emails you get from people who are outside of my district that don't like me. But I think in this situation, it's an entirely different environment.
I would be willing to expand my amendment to someone who was accused of a crime in that same jurisdiction. That's a good point. What I'm trying to avoid is somebody who just doesn't like a DA, 200 miles away from trying to come in and cause trouble for a DA that the voters elected. And that could happen to a Republican or a Democrat. And so I was trying to limit it as far as reasonable standing. And your example, that would be another way I would be willing to expand that to.
Yes, ma'am. And I think, and to put it in the best terms, I just don't think that would pass the smell test. Someone just coming outside attacking, because we've all dealt with the attacks from the 2020, and so I do know there are radicals out there on both sides that just go after elected individuals for no reason other than they're part of a different party, or maybe they have policies that don't necessarily line up with that voter's policies. And I think this system here will filter out those types of radicals. But I do appreciate that. Yes, ma'am. Thank you, Madam Leader.
Leader of Station.
Thank you, Madam Chair. Mr. Whip, know that we had a pretty vigorous debate on this issue as to who could bring complaints previously, but isn't it true for a member of the state bar, anyone can file a complaint against a member of the state bar? For a judge under JQC, anyone can file. You don't have to live in the circuit or have appeared before the judge to have standing to file. To report a crime, you can be anyone to report a crime. To file an ethics complaint against a member of the General Assembly, you can be anyone. You don't have to live in the legislative district. In other words, the whole point of the vetting process is to determine the credibility of the complaint, whether it's worthy of further investigation. Isn't that true?
That's absolutely true, Mr. Chairman. Thank you.
Wanted to talk about the avenues that are already available under existing law, and two specifically it sounds like were brought up, which is the ability to indict and remove an elected prosecutor, and also the voters to take action. Isn't it true that the example you gave of a judge who just left files sitting on the windowsill, so there's just no actions taken, or someone else, another elected judge who just doesn't take action, there's a remedy available by the JQC taking action currently, but there's no such remedy through an indictment for a prosecutor just not acting in certain cases, leaving the files in a stack on the windowsill.
You're absolutely right, Mr. Leader, that outside of criminal law, there are no guardrails that anyone's aware of. Even if they were, they don't know how to do that, and these were handled eventually.
In fact, there were allegations that there were prosecutors who may be engaged in sexual harassment, engaged in improper conduct within the office, had done things which are very clearly inappropriate, but may not reach the level of a specific indictable offense that would allow for a criminal prosecution to proceed. Isn't that true?
Absolutely.
Isn't it true that there are circumstances where an indictment only results after months of investigation, and over that period of time, an elected prosecutor has profound power to indict, decide what charges should be proceeded upon or not, and that without a remedy like the one you're presenting, effectively, with what's been discussed here today, the citizens of that jurisdiction would just have to wait on the indictment to come.
Yes, sir, and I would add, not only wait, but they would suffer, because and as you alluded to, I'm not sure that many appreciate the absolute power that a prosecutor carries.
Last question. Discussion was had over the ability of voters to throw out a prosecutor. Isn't it true that a prosecutor could potentially make prosecutorial decisions based upon what is best for his or her reelection, not what the prosecutor is mandated to do, which is to seek justice? And that under those circumstances, possibly the prosecutor could be reelected based upon his or her decision-making as to what's best politically.
Absolutely.
Thank you.
Thank you.
Chairman Leverett.
Thank you, Madam Chairman. Good, what is it now, afternoon? What planet I'm on, I can't remember. Good afternoon, Mr. Whip. One question, because to Representative Roberts' question, I actually sort of like that amendment that she had proposed too. But the one thing that gave me, I think, some comfort is I understand your bill and Representative Gullett's bill, you're proposing a structure for this commission in which you would have an investigative panel do an initial investigation to make effectively a probable cause type determination before the matter proceeds any further to involve the DA, who is the subject of the complaint.
Yes, sir, that's true. And again, that panel is made up of individuals who have been members of the bar, who have been members of the prosecutorial community, and some who have sat on a bench in the state of Georgia as a judge. And I just say this, and I know I don't think you'll find a more cynical elected official inside this building than me, but to challenge the integrity of a group of peers like that, I think usually comes from individuals who have not swam in the same pool, judicial pool that I have throughout my career. Integrity is extremely important to all those positions.
Thank you. And I would say to claim that you're the most cynical person in this building is quite a claim to be making.
Yes, sir.
But I believe it may be true.
Yes, sir.
And so my understanding is the JQC has a similar structure in which there's an investigative panel to screen complaints that are made for accuracy, and I think the panel also makes somewhat of a policy determination as well with the complaint if it falls within the framework that's set up for complaints and is accurate, and I guess can also make a judgment about whether it's in the interest of justice to proceed. Is that correct?
That is correct, and you remind me of a great point. You know when the investigation's going on, these investigators are leaning into Georgia code as to what is defined as the responsibilities of district attorneys and what is defined as the responsibilities of solicitor generals. So these are not men and women who are going out investigating based on what they feel are the obligations of these positions. But Georgia code has established what these individuals' responsibilities are. So we're not changing the playbook.
Are you aware, with respect to the JQC, how many complaints they get versus how many cases they actually take forward beyond the investigative panel?
No, sir, I don't. And the reason I know that in the circuit that I worked in, they had multiple complaints throughout my 30 years, but I can only recall, I think, 5 legitimate investigations. And of those 5 legitimate investigations, 3 of the judges who were investigated were disciplined, and all 3. 2 of the 3 retired.
And I guess to be fair, we aren't using the exact same standards because it's a different position, but I felt like the comparison might be illustrative. Anyway.
Yes, sir. And but to your point, the standards are written out in Georgia code as to what the responsibilities of a prosecutor is for solicitor generals and for district attorneys,
as well as the standards for the legitimate basis of complaint in your build.
Yes, sir.
Thank you, Madam Chair.
Thank you.
And I just want to point out, I know we've had long discussions on this bill before, but I'm looking at line 147 and 149. We're talking about prosecutors' willful and persistent failure to carry out duties. So those that are willfully and persist and continuously not doing what they're supposed to do, and looking at line 165, there are mechanisms. The commission is not just entertaining complaints just based on the charging basis of a charging decision. But there has to be an affidavit and documents attached that show why. So would you agree with me that that's kind of the intent of this bill, that we're going after those type of complaints?
Madam Chair, I think you've hit the nail on the head in both respect to where we discuss code sections 1518.6, 1518.66, and absolutely on what the commission should and should not be investigating.
And last question, Representative Miller.
Thank you, Madam Chair. So just to wrap up, and since we're on the topic of being cynical, some of the folks who are critical of this bill have stated that, when Democrats attempted to do the same thing in the wake of the Ahmaud Arbery killing, that no Republicans supported that effort. And it wasn't until Republicans were frustrated with certain Democratic district attorneys from certain counties, which have been named often Athens, Clarke County, that this all of a sudden became a crisis in Georgia, that prosecutors are just out of control, so much so that we need to establish this very robust layer of state oversight. What do you say to that? One, did you support it when the measure was explored by Democrats in the wake of the Ahmaud Arbery case? And 2, what would you say to the very real concern that there were a remarkable number of minority DAs elected in 2020. We went from maybe 4 or 5 to, someone will correct me, 20. And some of these DAs ran on platforms that their constituents, that resonated with their constituents. Those platforms being criminal justice reform related. What would you say to the folks who say that this is just an effort to circumvent the will of the majority of voters? Because if we take those sort of democratically elected DAs and count up the number of constituents they have, it's the majority of Georgians. That there are folks in this assembly that are creating pathways, attempting to create pathways through this legislation to undermine the will of the majority of Georgians who have elected these prosecutors, however you want to label them, because they represent the values in those communities. That was a long question.
Oh, no.
And cynical,
No,
I'm
that's
sorry.
fine. I'll try to unpack it best I can. First of all, I don't know the race of the district attorneys in the state of Georgia. I can tell you that the district attorney that my phone was blowing up over was a white male, and he was a member of the Democratic Party. But the people that were calling me with concerns, crime victims, families, and others, they were not calling me because he was a Democrat or any policies. They were calling me because of actual misconduct. And that's where I talked about the video and things of that. I think you and I both had concerns with the district attorney down on the coast. I'm not sure of what party she's a part of. The only way I could identify her is from photographs in the newspaper. I've never met her, but what I do know is prior to that case, because of relationships I have within state law enforcement, that I knew there were issues in other cases, and she had been reelected since those other cases. No complaints had been filed, but these were situations where lives were actually lost involving that particular judicial circuit. And so while I appreciate, and the bill I believe that you're talking about that was presented by the Democrats, I believe was a House bill that did not go anywhere. And I'll be honest with you, when I discovered that bill during research on this within the last 12 months, because I stood on the roof of the parking deck at the Atlanta Police Department and called out the Fulton County District Attorney, who was Paul Howard at the time, for the way he was prosecuting law enforcement officers while neglecting his responsibility to protect the citizens of Fulton County from rapid crime. So while I think it's easy for someone to throw out, that, hey, it's a partisan thing, it's a racial thing, and all this other stuff, the one person that I know and the people in this building that know me understand that thanks to my cynicism, I'm extremely logical thinking, which again is a crippling effect in this building many days. But no, it doesn't. I was, I happen to be a state senator, but look, I'm a law enforcement officer, 100%. And Title 16 and Title 40 are very clear. In the courtroom, the rules are very clear. In a grand jury, the rules are very clear. Man, woman, the group I come from that wear a badge, we're all different colors, we're all different shapes and sizes, we're all different orientations in our faith and our sexuality and everything else. I find it has probably been one of the least racially driven or politically driven professions that I've ever been around, and I'm proud to be a part of that. And I promise you, if I were to bring a bill based on some of the things that you mentioned, I wouldn't be able to do that. My conscience would not allow me to do that. But I did discover the piece of legislation, and while it apparently didn't get any support, I wished it would have. But what I was told also, when I asked why didn't it go anywhere, I was told that the authors of the bill did not ask for a hearing, is what I was told. But I've never been a member of the House. It's a great part of our government. I've just never been a member. Thank you. I appreciate that.
Representative Gullett.
Yeah, I do want to just clarify the record. This is something that the House Republicans have been working on. This was an idea that I had broached with my seatmate back in 2020 during the Ahmaud Arbery efforts or problems that were going on because of my DA in Paulding County, and was trying to figure out my path forward. And that's when the Democrats, at that time, William Bodie, dropped the measure. But it's something, I don't think it's fair to say it's something all of a sudden after the elections where some minority members became district attorneys, that all of a sudden this has become a priority for Republicans. This is something that I've been working on as a Republican in my county since before that, and it's something I'm going to continue to work on until we get this through. So I appreciate you bringing the measure on your side. I appreciate what you're doing. And I'm sorry for the problems you've had down in Columbus. I'm sorry for the problems my people have had in Paulding County. I'm sorry for the folks in Glenn County with the Ahmaud Arbery stuff. I'm sorry for the people in Fulton County who dealt with Paul Howard before he was beat. I'm sorry for the folks in Hall County who are having a solicitor problem currently. I'm sorry for the people in Athens, Clark County. And I'm sure there are more that I don't know that I didn't mention, but there are a number of issues with district attorneys and solicitors. While most are good, there are some who are not, and this is addressing those. And that's all this is doing, but it's not fair to say this is something that we all of a sudden become a priority of us. This is something that I've been working on as a member of the House since before, and something I'm going to continue to work on until we get it done. So thank you.
Thank you. In full disclosure, Madam Chair, Representative Gullett is an alum of Columbus State University, so I just want to make sure.
Thank you. We really needed to know that, yes. I'm going to go ahead and hear from several people have signed up. So I'm going to go ahead and hear from James Woodall first. And again, I am going to keep the testimony to 3 minutes. If you can state your name, and I know you've been in front of this committee a lot, but if you can state your name and where you're from.
Well, definitely. Thank you, Madam Chair, and to the members of the committee. My name is James Woodall. I'm Policy Associate at the Southern Center for Human Rights. I want to start actually the bill we just considered before, which is House Bill 272, and why I think this bill is, what I'm about to share on this bill is important. There was a case, very briefly, there was a case in Statesboro, Georgia, Bullitt County, which Representative Roberts mentioned, where a domestic violence victim was sentenced to, she was charged with felony murder, but was found not guilty, but was still sent to prison for 10 years for 1 count of ag assault and 1 count of possession of a firearm during the commission of a crime. And she killed her boyfriend, who was her abuser, in which the prosecutor in that case had actually prosecuted the very abuser, which she ultimately killed 4 years later. And that case is now before the Court of Appeals, or is going through the appeals process. And this is a occurring pattern in this particular circuit. The reason I want to start there is because this is an issue that, Leader Evstration on the floor talked about the stands your ground in Ahmaud Arbery. I was one of the ones that were in the room and witnessed what he referenced. And so this is something over the course of my career I've been very invested in. So this is not just an issue that's popped up now. I say that because this prosecutor that prosecuted Ashlyn Griffin in February of 2022, according to this legislation, would not be eligible for oversight. Sending innocent people, in which the Code of Georgia, the official Code of Georgia says should be immune from prosecution, are currently right now sitting in prison. And I believe that is that is as egregious, if not more, than what I've heard today. Innocent people sitting in prison, victims of domestic violence, human trafficking, whatever, sitting in prison based on the charging decisions of a prosecutor in this state. Now I turn to the actual bill itself, and again, I'll mention that prosecutor actually signed onto the letter that the sponsor referenced. So that prosecutor is saying we want oversight, but the actions that she has taken is not going to be subjected to that oversight. But now I turn to the section on page 3, which is the portion that talks about the 5 members of the commission's investigative panel. I do agree that having the members of the state's judiciary elect or appoint members is problematic because of obvious reasons. But what I don't agree with is removing the citizens from being able to also be a part of this process. If you talk about the JQC, there are two citizens that neither of whom are members of the state bar, which are appointed by the governor. And I think if you're going to have a panel that oversees the actions of local prosecutors, you do need still the voice of those persons who are in that community. And so maybe it is not limited to the actual complainant itself, but you do still need to have citizen representation on those commissions. Secondly, I'll also raise one issue related to the definition of misconduct. Is not defined anywhere. There's nowhere in the code that defines it. And so by virtue of there being no definition, you're going to have members of that commission define what that misconduct is. The reason why I find that problematic is because when through the sponsors, the sponsor of the House version mentioned what's happening in Athens-Clarke County, there have been deliberate actions to ensure that that prosecutor does not have the resources, does not have the staff, does not have, quite frankly, the time to be able to do her job effectively. And so to come here and say that that prosecutor is not doing their job when there's an ignorance to the fact that that prosecutor has had numerous open records requests filed, which also, per Georgia's law, has to be responded to timely, and then has to use staff time, has to use resources, and there's open records requests time in and time out. And then now there's a written mandamus that was filed charging that some of the same issues came up there, which the Attorney General has not agreed to represent that person in that matter. I say all that to say is we have issues related to prosecutor misconduct here in the state of Georgia. There are avenues to approach them which are not sufficient. I want to be very clear that I'm not sitting here saying that we have, what we need to address this issue. What I'm suggesting, this is not that, because everything that's outlined in this bill is already covered under law, which has been said before, but the Attorney General hasn't done his job in actually bringing forth those indictments. Secondly, by time this actually is adjudicated, Senator Robertson talked about the length of time, and Representative Miller asked him how long these cases take. They take at least 4, 5, 6 years. It's not going to happen quicker than the Attorney General can do his job or her job if she's elected. And so I say all that in closing, that we have an issue. And I do understand the urgency of trying to address this because innocent people's lives are at stake. It's not just enough for us to talk about what cases are not being prosecuted. It's also just as important to talk about what is being prosecuted and why innocent people are sitting in prison today. So with that, Madam Chair, I'll pause, and if there's any questions, I'll answer. If not, thank you for this time.
I don't see any questions. Thank you. All right. The Douglas County DA, Dahlia Ricine.
Almost brought up my phone as a timer because it's dangerous giving a lawyer a microphone. So please stop me at the appropriate time. I apologize in advance if my thoughts are somewhat scattered.
And if you can pull one of the
yes.
mics.
Is that
to
better?
you. Perfect. Thank you.
I've had the distinct pleasure of being in the trenches with some of the members of this committee throughout my prosecution career. But here to speak on opposing Senate Bill 92. I want to first correct one of the statements that was made about 50% of the DAs support this bill. That is incorrect. There were 21 who signed on. 3 of those have recently been appointed by the governor to judicial positions. And the support of that letter coincided soon thereafter a meeting with the Attorney General. The first point I do want to bring up is if we think this is such a good idea, why is the Attorney General not included? He is a prosecutor here in our state, and somehow dubiously he has been not added as to being under the purview of this commission. I think there was also a statement that along the lines that we are held to the same standard as our law enforcement partners and judges within the criminal justice system, where obviously there are opportunities of impact to do grave injustices if any of those people are not pointed in the right direction in the work that they are doing. But I would like to make a correction that we are not held to the same standard. We are held to a higher standard. And that is encapsulated within our ethic rules of 3.8, Rule 3.8, which places us at a much higher standard than anybody else within the criminal justice system. And it is a tool and remedy that is very effective in those provisions. And I know that in the past, having testified on behalf of the House bill that was also presented, that there is a expediency that it is believed that this commission will be remedying. I don't think that, we all know nothing in government is quick. And so I do not feel that that would fulfill any obligations or desires for that to happen as well. In addition, I know that there's been a lot of comparisons saying, well, there's the JQC. Well, the reality is that not all judges have to be lawyers. In fact, in Douglas County, we have a magistrate judge who is not a lawyer. She's probably one of the best judges that we have. But for smaller jurisdictions, previously, you were not required to be a lawyer in order to be a judge in your community. And so the reason that there is a need for the JQC is because all those state bar rules, all those ethical rules don't apply. And so that is why there is a need. And I think it was brought up earlier by Representative Miller about the cost comparison. I heard a $1.4 million quote for this commission. I believe the JQC is approximately 1.5. And to clarify, there are over 2,000 judges in the state of Georgia. There are only slightly over 200 elected prosecutors between Solicitor General and DAs. And so the fiscal implication of having this type of commission, where we are expending $1.5 million, it's in essence equates to about $1,250 per elected, to monitor, to see what is happening with them. We know that there has been very specific mention of at least 2 different individuals that this bill is meant to target that are currently in office. But if you think about 50 DAs, that is $30,000 per DA. $30,000 per DA to babysit us. When we already have ethics rules, we already have all these things in place. We are required to be lawyers to serve in this role. So the fiscal irresponsibility, when there are already adequate remedies, example after example has shown that the parameters that are in place are removing our unethical and our immoral counterparts. And nothing, unfortunately, is going to be able to cure us of all of those, right? We are humans, and so that is going to be present at some place. But it does tantamount to a voter suppression. I am part of that 2020 contingency that was referred to of not just women, but women of color who came in and recognized that we have a criminal justice system that has imposed gross disparities. And not only is it our obligation to ensure that we are serving our communities currently fairly and equitably, but we also have an obligation to correct past wrongs. And to handcuff us and to say that we don't know what's best for our own communities when our voters are very clear on what we stand for, very clear on what we're doing, it is tantamount to telling them, oh, you guys just don't know what you're doing, so we're just going to choose your elected prosecutors for you. So I feel that in having these combined, that it is something that we have to be very cognizant of as we're pushing forward. And I want to draw attention specifically to lines 175 to 177 of the bill, which in essence says that anybody, we've already discussed, there is no standing parameters. There is no, that anybody that says something that is disliked, that in essence, they can then be cited and referred to the commission. I like to call this provision the shut up and dribble portion of the bill, where somehow we are held to the same standard of judges who are umpires. They're refs. They are supposed to be unbiased. We are advocates. We stand up for our community. We sometimes have to take the position of unpopular opinions. We have to be there and stand in the gap when the system maybe is not working in the way that it is supposed to. That is our job. And so to tell us that we cannot speak, I don't understand what the difference is between anybody in this room who has run and been elected for a position and made it very clear where they stand and where we do. And somehow when we do it, it's a problem. So that is why I am opposed to this bill, because the work that we are doing is hard enough. We have solicitors here who are being lambasted for saying they won't prosecute marijuana, but in this same Capitol, in other committee rooms, we are talking about how people can make millions off of selling it here. We have people sitting, waiting in jail for months on end for things that others are going to profit off of. And so when they say, I don't have the resources to prosecute misdemeanor marijuana because GBI doesn't have the money to do the testing that is now required for us to prove elements of marijuana, again, they're told they're wrong. Shut up and dribble. So I will stop at that. That is my position on why this is not a good idea. I could give you 50 others, but I will be respectful of the time that has been allotted. I know there are a lot of people who want to speak on this, but I also want to be very clear, and I'm sure my counterparts with the Solicitor General's Association will correct me if I'm wrong, but the Solicitor General's Association and the DA's Association official position is to oppose this bill, because I keep hearing about this rogue letter that has been issued, which is not the sentiment of the majority of electeds, who realize how damaging this can be for those of us that already have what seems like an impossible job to do.
Thank you. You have one question. Representative Miller?
First of all, let me just say that the reason why I, as a current defense attorney, am so opposed to this bill is because my feeling is that it is targeting good, honest, hardworking, well-meaning district attorneys who have spent their entire career on the front lines fighting for victims. And there is, correct me if I'm wrong, Madam DA, your area of expertise prior to becoming the elected DA in Douglas County was crimes against women and children and human trafficking prosecutions. Is that correct?
That is correct.
And you have probably tried more cases than you can count on behalf of the least of those. Is that also correct?
Absolutely.
And when you ran for office in Douglas County, did you tell your constituents, the potential voters, that what your objectives were and what your priorities would be if they elected you?
Absolutely. I was very transparent in what I would do as serving as our community's DA.
Okay. And while I know that I cannot imagine that this body would do anything other than support DAs like you who are doing this important work on behalf of our communities, I want to apologize because I know you well and I know that this hurts you. And so I want to apologize to you personally for this thankless measure that does nothing to support what you and so many others do day in and day out with little to no money, because you care about public safety and you put your body on the line to represent those folks. So I just wanted to say thank you for the work that you do and thank you for your testimony.
Thank you, Representative Miller.
Representative Roberts?
Thank you, Madam Chair. Thank you for being here today and providing your testimony. So can you just give me a ballpark figure of how many cases you're handling at one time?
Yeah, so we estimate probably around 3,500 that we've received from the previous year.
Okay, and how many attorneys do you have covering those cases?
We currently have 4 ADAs assigned per courtroom, which is a total of 12 because we have 3 judges. We have 2 in our juvenile courts and 1 that handles our accountability courts and 1 appellate.
Okay, do that math for me. How many lawyers is that total?
17, but total on staff we have about 23.
For 3,500 cases?
Correct.
Okay. And how do you said you were transparent when you ran for office? How do you prioritize the cases that you choose with your prosecutorial discretion, which you are granted?
Yeah, great question. So my 3 pillars that I rule with as my guiding light is number 1, my own victimization as a child, to make sure that we are advocating for victims who are traumatized by what they've been through. Secondly, through my own brother who passed away from his addiction. So what can we do that's innovative in that space? And I'm sorry, let me get myself together. Okay. But what can we do that's different? Because the very definition of insanity is doing the same thing over and over again and expecting different results. As a touch point for most people who have addictions to come through, which is the criminal justice system, what can we do that's different? What can we do to build safer communities so that we can make sure that these individuals are given an opportunity to be healthy and productive citizens versus continuing to victimize and criminalize those? in our community. And thirdly, I am the proud parent of 3 black children, where a system that I am sometimes terrified to work in. Making sure that our system is fair, making sure our system is just, making sure that our system treats people equally and with dignity is tantamount to what I implore my folks to do. And so with that, it's hard to say, hey, we're going to prioritize this or that. But what I will say is that obviously under those guidelines, and I think most of us would agree, especially those of us in the felony world, that serious violent felonies are exploding in all of our communities. I don't care what political affiliation you have. And what we also recognize, there's a lot of hurt. There's a lot of hurt in our communities, and hurt people hurt people. And so trying to figure out ways that we can handle those really intensive, extensive investigations with turning, like I think I said between the House Committee, we specialize in making $1 out of 15 cents. We have to figure out ways to make sure that we can keep our communities safe by keeping dangerous offenders accountable and responsible for their conduct. And it's not easy. And so to have another layer of another responsibility for people to criticize, critique, and potentially remove us from what we are doing while we are just simply trying to do our best. And what works in Douglas County may not work in Tifton, Georgia, and vice versa. But we are the reason why this is a locally elected position, despite the fact of having a state position, is because we have the responsibility to know and respond to our individual communities.
One last question, Chair. So, legislators, we don't make a large salary either. I suspect that DAs and Solicitor Generals don't as well. So is it safe to say that you're not in this for the money?
Very safe to say. I
Yes.
talked to some of my friends who are in either criminal law world or civil world, and, it is quite a difference in what we're able to bring home.
Thank you for your service.
Thank you.
Thank you, Madam DA. Thank you. Taylor Hawkins.
Thank you, Madam Chair. Taylor Hawkins with Frontline Policy Action. Our organization's goal is to protect families and family values across our state. And just wanted to thank the Majority Whip in the Senate, Senator Robertson, for his work on this bill. We have heard from our supporters all across the state as public safety is a rising issue, especially in some urban areas. And I just want to thank him for his effort and just mention our support of this bill and that we wholly endorse both its aims as well as the means they are taking to accomplish that. So thank you very much, and would ask this committee do pass.
Thank you. Coweta DA Cranford.
Right,
Thank you,
Madam
DA.
Chair, everybody. So I'm Herb Cranford. I'm the DA in the Coweta Judicial Circuit. Just to give you a little background, that's Coweta, Carroll, Troup, Meriwether, and Heard counties. So out of the 50 circuits, you've heard a little bit about caseloads. We've got the 4th highest felony caseload, according to the Administrative Office of Courts, the 5th highest population out of 50 circuits. But my smallest county, Heard County, has got 10,000 people. So it's a unique blend of counties. So I've got the experience of being a big office with a high caseload, but also running a really rural, small county. So I think that gives me an interesting perspective. I am a supporter of the bill. This idea first got on my radar with the bill that was discussed, I think, in 2021, first raised by Democrats. I think it was then Representative Trammell that was responsible for the bill, along with Representative Bodie. So Representative Trammell was in my circuit, so I was kind of aware of it. And in fact, New York Times reached out to me in the last few weeks asking me about this stuff, and I went back through some old emails I'd saved, and my response to the bill dropped by Representative Trammell was, I'm inclined to support this. And that's because I saw behavior of other elected prosecutors across the state that concerned me. And, for example, sexual harassment that's been raised, I didn't see a good way to deal with that. Yes, there are elected prosecutors who have been prosecuted and removed from office by elections, but on balance, I just wasn't satisfied that we had the mechanisms to deal with every bad actor that might come through. Initially, in discussing the bill dropped last year and discussing this bill, I've conveyed in writing concerns I have about, creating a bureaucracy that might be weaponized, that might be used in a bad way. But I think that's a concern with every bureaucracy. So my concern became, can we engage with the legislature to get as good a bill as possible to mitigate as much as humanly possible this commission being used in a bad way, being weaponized, being partisan. And one of our biggest, I would say my two biggest focuses in engaging the legislature, and I want to say I truly appreciate Senator Roberts and Representative Gullett and others listening to my concerns and concerns of other elected prosecutors, and they've made a lot of changes to these bills that we requested, and I think those are good changes to mitigate against the concerns we had. But two of those main changes were getting the right people on the commission, as we've discussed today, people with actual prosecution experience. I appreciate the interest in maybe having a citizen member, but this job is very unique. As an assistant DA, you would think an assistant DA has a good idea of what it's like to be the DA. I did that for 5 years before becoming DA in 2018. I did not have a good sense, even as an assistant DA, of the decisions a DA is making on a daily basis. So I think to protect against abuse, it is really important to have people with prosecution experience, especially experience as an elected prosecutor. And I think this bill, as you've seen, does that. The second thing that I wanted to make sure the bill accomplished regards discretion. And that's been a controversial aspect of this bill. And I think we requested or suggested that this bill be dovetailed with requiring individual case review by prosecutors. That would, in my view, actually preserve a prosecutor's ability on individual cases, in every case they look at, to do what they think is right, to do what they think is in the interest of their community, to act in a way that's consistent with the reason their constituents elected them. If they wanted to prioritize their limited resources on prosecuting violent crimes instead of marijuana, this would allow them and preserve their discretion to do that, in my view. For example, you can look at each individual case of marijuana and say, I decline to prosecute that because I want to use my resources elsewhere. I think what defining individual case review would only prevent, the only thing that it would prevent, as referenced in this bill, is categorically deciding I'm not going to prosecute entire provisions of law. And as I've communicated before, I do think that oversteps some line that exists between those who create law and those like me who enforce law. So I genuinely believe this preserves our discretion to do what we think is right on every individual case. You would just have to make a decision based on the individual case. Those are the two main things I wanted to speak to in support of the bill. I think the changes, the things in this Senate bill, I'm supportive of. I'm not sitting here asking for changes to this bill. I'm just speaking in support of it. Happy to take any questions that any of you have.
Any questions? Thank you. We don't have any questions.
All right, thank you.
All right, and DA Barksdale?
I want to first apologize for the poor handwriting. I kind of got a chuckle watching you try to decipher
You
that
did, yes.
handwriting.
We looked it up. We got it. Thank you.
So I apologize for that. Again, my name's T. Wright Barksdale. I'm the district attorney for the Okmulgee Judicial Circuit. It's an 8-county circuit that is comprised of Morgan, Greene, Jasper, Putnam, Hancock, Jones, Baldwin, and Wilkinson County. The two things that well, I'll start with I support this bill. I've worked alongside several folks this year to try to iron out the details of what this would look like. So I appreciate everybody's hard work on that. I am one of the 21 that signed the letter of support. I believe that letter also included our support for DAs being nonpartisan. I think it's very, very important to understand that this movement started before I was elected 2.5, 3 years ago, where there were more minorities added. I have no problem with that. They're very, very talented district attorneys that have done a great job, and I commend them for their work. But it's important to understand this started because of Dick Donovan in Paulding County. This started because of Jackie Johnson in Glenn County. So I want to make sure that is clear. But I also want to make sure that you understand that the 21 of us that support this made an attempt to get behind the nonpartisan bill that would make us nonpartisan. I'm even, and I only speak for myself here on this particular issue. There's 8 members in this proposed bill. I'm in support of, look, do 4 Republicans, 4 Democrats. What we want to make sure is, if you read this language, who really in this room is against having some type of mechanism to hold a DA accountable if they make charging decisions, or they make a recommendation because they're financially motivated, or they have some undue bias, or they have committed a felony offense? Who here in this room wants to stand up and say we're against having that type of oversight? What we have worked hard to do this year with the help of people in this room is to try to craft a bill, put politics aside, and try to make sure that what we are doing is focusing on the victims of this state, making sure our communities are safe. And I'll say this because Dahlia was talking about it. We are underfunded. When you talk about a concern about the quality of prosecution in this state, we need more resources. We need more funding to keep our best and brightest prosecutors. So I just want to make sure that I think I've ironed out everything I want to talk about, with the exception of I support the Senate version of this. I think it's important, echoing Herb Cranford's viewpoint, which is prosecutors and people with prosecuting experience need to be on these panels. And that came no clearer than what Mr. Gunner said earlier today when he said I had 4 budgets or 6 different budgets. You need somebody in the chair that understands what we're doing every day, and that's very, very important. So I appreciate everybody's time. I tried to limit it to 3 minutes. I may have gone 5.
Right. Thank you. You actually have a few questions. Representative Miller?
You did good. With the time. Thank you for your giving us your perspective. You said a couple of things that I just want to ask you some follow-up on. One was the example where you said, I don't think any of us in this room would be against, having a mechanism to deal with prosecutors who take money in exchange for, decisions on indictment, et cetera.
Sure.
All of those things that you named would be a violation of that prosecutor's oath of office. Would you not agree?
I would agree with that.
Okay. And so there is a mechanism already in place without this commission to deal with prosecutors who do all the things that you just named.
I would agree with that. I would assume that under that circumstance, there would be an investigation, there would be an arrest warrant taken, more than likely. The case would be turned over to a prosecutor. Obviously, PAC would have to get involved. There would be a conflict prosecutor. That would take quite a bit of time. It would be presented to a grand jury. It would be placed on an arraignment calendar, and then it would be put at the very back of a trial calendar. And I know you said you were a defense attorney, so you recognize that the dockets are full. Mm-hmm. I may be able to be DA for another 6 years before the case is ever going to reach a jury of my peers.
Okay.
And what I wanted to point out is what we're really talking about here is not going after people because of what political party they are, or what color they are, or what, but we want to make sure that if there's something so egregious, like the guy that was the Columbus DA. Okay, that infuriated me because of what Dahlia and others do every single day for their community. It gives us a black eye. What we want to make sure is that when it's so blatant, that there's a mechanism for the victims and citizens of Georgia to have some immediate consequences rather than what you're talking about, which I agree with you, they need to be indicted. But as you know, the wheels of justice are moving slow in today's time.
Just to follow up, Madam Chair. So I think I'm not sure that you would be able to remove a prosecutor through this commission any faster than it would take the Attorney General to investigate and indict, because there will be appeals, there will be lawyers. It's going to take some time. But I guess to your point, I do want to add that if the Attorney General gets a complaint from a victim or a citizen, and the Attorney General investigates and decides to indict, the governor would have the ability to immediately suspend that elected district attorney and remove him from office. So that would short circuit some of the time that you described it taking a case to matriculate through the system. We've seen the governor do that in other instances. Would you agree with that?
I have not seen the law as to how that would work. Okay. I know that as to sheriffs, there's a mechanism in place. I'm not sure about elected district attorneys.
Okay, thank you. And I forgot my other question, which is probably a good thing.
Chairman Smith.
We're not talking about John Adams.
You know what? You knew exactly what I was going to ask. Have you looked anything up on him yet?
I tried. I grabbed a couple of Wikipedia pages to try to get up to speed on that.
Okay, because when you told me you'd vote against the first lawyer to ever be president of the United States, had you been voting then or he ran today, I was a little concerned. So I'm going to send you a copy of the McCullough biography on him, because we got to convince you to vote for John Adams, hypothetically.
I look forward to it.
All right. Thank you.
Representative Mogul.
Thank you, Madam Chair. Do you have any data on how many prosecutors, solicitor generals, district attorneys are under investigation currently for any misconduct?
That would be something that I would not, as the district attorney for my circuit, be allowed to know. That would be more than likely they're going to be investigated by the GBI, and the GBI is not going to disclose to me an investigation from a DA in another circuit.
Thank you, DA. That's all.
Thank you, and I'll write better next time.
Thank you. All right, those are all the testimonies. Any discussion from the committee? Representative Miller, I was waiting.
I know you were. I didn't want to let you down. I'm either really quiet or I have a lot to say. That's kind of the way it goes. But I will not talk long. I think everybody, all my colleagues already know all the reasons why we oppose this bill. I do think that Madam DA Racine's observation that this bill leaves out certain prosecutors, to wit, the Attorney General, lends credence to the criticism that this is a politically motivated exercise. And whether that is intentional or not, that is certainly the perception by many, including folks in my community who I have heard a great deal from, who are opposed to a prosecutor's oversight commission, by whatever we call it. I don't think being opposed to this commission should equate to being opposed to holding prosecutors accountable. In addition to doing criminal defense, I do civil rights, and I was a prosecutor for many, many years and spent a significant amount of time in the trenches with DA Racine and others. This is about a waste of taxpayer dollars, because there are already efficient ways to do this. We could easily fund the Attorney General's office with more money for more staff to have a robust unit that could move quickly on complaints about district attorneys, indict them when it's appropriate, and then have them suspended immediately. That, surprisingly, does not take as long as folks think It would if the evidence is there. So for the reasons that I've stated previously, while I agree with the idea that prosecutors should be held accountable when they violate the law, I do not agree with this bill because it wastes taxpayer money. We already have mechanisms in place that have worked effectively. We have mechanisms in place that we have not even tried to use yet. And this allows partisan appointments of folks to supervise partisan DAs from the opposite party, potentially. And it just smacks of political retaliation. And so for that reason, I won't support this bill.
Thank you, Representative. Majority Whip Robertson, I'll give you the last word, 3 minutes. And we're going to do a hearing only on this today.
Yes, ma'am, and I appreciate that, and I
Thank
hope I
you.
don't take 3 minutes. This is a very well-written piece of legislation. It's very clear. The problem that we have is extremely clear. Everybody that has come up, said that everybody should be held, to a high standard, and I heard some say higher standard, and that's the purpose of this legislation. It is obvious over the past few years that we have had several that do not feel that standard is applicable to them, and this legislation goes a long way in not only protecting something that should be protected, which is our criminal justice system, but also the 11 million men and women who live in the state of Georgia that believe in due process and believe in a non-biased criminal justice system. So I'm extremely proud of this legislation and look forward to a vote from the committee at the right time. And thank you for your time today, and I appreciate the consideration of the committee.
Thank you.
Yes, ma'am.
And don't go too far, actually. We have one more bill on the calendar, and it's Majority Whip Robertson's.
Is it mine?
Yes, it is.
We love our dandy Randy.
It's Senate Bill 63.
Is this birth certificates for adopted children?
I
I think, no, that was yesterday, but.
think that's correct.
Not so lucky. Huh? Yes, adults, most adopted children did not have access to their birth certificate, their original birth certificate, unless they went through a pretty heavy process in the court system. But the House corrected that with us yesterday. We were able to get it through committee yesterday over here in the House. Yes, ma'am.
Okay, we'll let the room clear out a little bit, and okay, when you're ready.
That's right.
Only have to.
Well, and I'm gonna drive ahead hard, and do not plan on taking up as much of the committee's time with this. This is, and Madam Chair, I believe we're all reading off of SB 63 CSFA. Is that correct? And what this is this is the second half of a two-part journey that we started a couple of years ago, dealing with bail bond reform here in Georgia, where we identified particular laws that were that would require individuals who were arrested to have to post bond. And this year, based on a lot of the issues that we've been concerned about with the eco-terrorism that has occurred here in the city of Atlanta, and that seems to have taken root around our country, that we feel there was a need to add a few other bail-restricted offenses to the list. And so we have done that. And going through this process, that we ran into a few unique obstacles. One was something that the bail bond community had attempted to use this to kind of change something within their community. We were able to push back on that, and maintain the responsibilities that are currently required under Title 17. But again, like I said, this is the second half of that bill, and in doing this legislation, another thing we have discovered, and I have Senate research doing that now, is we have a tremendous amount of felonies on the state of Georgia that are not normally would not be classified necessarily as criminal offenses in the typical sense. A few of them are, selling onions, claiming that they are Vidalia, and they're not. We felt that that could be something better handled in a civil situation as opposed to a criminal situation. So, exactly, and selling cotton without paying tax. So what we've done is I've engaged Senate research, and we are attempting to pull all of those out, and to hopefully at some point before next session have a piece of legislation where we can reclassify those and get those individual charges away from any opportunity of ending up in any of our jails here in Georgia. But it's been a great exercise. But if you read through the vast majority of the laws that were already in the bill, we've made a few adjustments, which has caused a tremendous amount of underlining, but a lot of it is only because it's moved one line down on the legislation. So with that, Madam Chair, I'll engage any questions to those, because I'm sure that the committee has read and has a very clear understanding of the legislation.
Thank you. Any questions from the committee? Representative Miller.
Thank you, Madam Chair. Thank you, Senator. I did spend some time reading your bill.
Thank you.
You're welcome. And I had some pretty significant concerns. Is it your intent, and I just want to make sure I'm understanding it, is it your intent to add all of the offenses starting at line 92 to offenses that the court must obtain a cash bond for in order to release someone?
They must. A bond must be posted. Yes, ma'am.
Okay. And what is the rationale for that?
Well, I wish I would have brought it. It's a very voluminous document that documents all of the failure to appears for the vast majority of these types of cases throughout the state of Georgia. And what we have determined is since the last legislation passed, we've seen the correction in the charges, the violent charges that were committed there. We've seen the corrections of the individuals posting bonds, staying engaged within the system, showing up to hearings and doing what they're supposed to do, but also working within the system to try to get ahead of the court system if you can through pre-trial diversion and other programs. But what we continue to see is a disproportionate amount of individuals not showing up to court. And so, but we've also seen an evolution within the criminal justice system too, where we have certain parts of the state. I looked at one the other day on a spreadsheet where one circuit had an individual charged with obstruction of a law enforcement officer and a few other charges that went along with that, and the bond on that was $15. Because what the court is doing is it's determining the ability of the individual to post a bond, and it's setting the bond at a reasonable amount. And the positive of that is that individual is now provided all the information necessary so that the courts know where he or she may be, and at the same time, that individual has skin in the game, if you will, to stay engaged in the criminal justice system.
Okay, so I am not familiar with your FTA research, so I would look forward to reading that. I would wonder what percentage of those FTAs were set aside. Were any of those FTAs as a result of failure to receive notice? And the reason why I ask that is because I am from Fulton County. That's where I was a prosecutor for many years. It's where I live. It's where I now practice criminal law. And I don't know if you know our sheriff, Pat Labatt, who is doing the best he can to manage the Fulton County Jail.
I spoke at his graduation from the Sheriff's Academy.
Okay, then you know he's a fine man.
Yes, ma'am.
With a fine reputation. And I cannot imagine what having someone charged with marijuana or forgery, what having all of these individuals sitting in his jail waiting for the judges who then have to get on a calendar, who then have to have bond hearings, who then have to appoint public defenders to represent these people, what that would do to clog up the already extremely overburdened Fulton County criminal justice system. I wonder if you have thought about what this would do to large metro places like Fulton County, where we right now have people sleeping on floors. There just is not enough space in our jail to hold violent offenders, let alone to have our Fulton County, sheriff's staff, transporting and manning someone with reckless driving because we've got to get them in front of a judge and then they have to post $15 to get a bond. I just don't, I'm not understanding how the extreme burden on the system would be outweighed by this idea that if someone posts $5 or $10 or $15, then they're definitely going to come to court as opposed to not.
Yes, ma'am, and I don't think I've used the word definitely, and I don't think you can use the word definitely in the criminal justice system when it comes to the behavior of individuals accused of crimes and even those convicted of crimes. But what we have found is that some jurisdictions, jurisdictions like you're talking about, jurisdictions, and for several years early in my career, I worked in an overcrowded jail where individuals didn't sleep on the floor. Federal government requires something a little different than that. They do a plastic, what we used to call them was a boat, but it would sit on the floor so the individual would not be laying on the concrete floor, but we were overcrowded. And what we did is we got with our judiciary and we got with the available programs within the community and established a process where individuals could post bond. The bonds were lower and they were able to get out of jail. But at the same time, those individuals knew then that they were engaged in the system. And a lot of times there is disengagement, such as the individual in one county who was charged, which led to this legislation starting a couple of years ago, that was charged with crimes, released out of jail under his signature bond, went out and committed the same crime involving a firearm, and then went back to jail and then was released again and went back and did the exact same crime again involving the firearm. And that was up here in the metro Atlanta area. And so what citizens were pushing back, and again, I think one thing we have to do when we start talking about the weights that are put on the criminal justice system, what we tend to do, and when I say we, I'm including all parts of the criminal justice system because I'm proud to be a cog in that massive system, is that many times we fail to put on the scales the rights of the victims. Not only the rights of the victims looking for justice, but the rights of the victims to know that they have a criminal justice system that stands up for them and protects them. And in many times when, and I always pause before I use the phrase, but when we tend to slap the offender on the back of the hand, or worse, pat the offender on the back and say, hey, do me a favor, we're going to let you sign this, or we're going to let you just have an OR bond. Please show up for court and please don't bother anybody again. Sadly, what we find in the vast majority of the cases is that the individuals choose not to become a part of it. And in the FTA portion of this, I think it's on the second offense that it would become that. So the individual at some level is already engaged in the criminal justice process. But we have seen some districts that were mentioned in the previous legislation that some individuals might want to classify as more liberal, use this to their advantage and set these bonds, reasonable bonds, I'm sure based on the physical ability of the individual engaged in the system to make sure that they were released on bond after all of the information necessary to track this person through the criminal justice system was obtained.
So is it your belief then that if people get released on unsecured judicial bonds that the system has no way of tracking them, but if they post $15, the system would then have a way to track them?
It's my knowledge that they have a lesser secure system of following them.
Based on?
based on history and based on my occupation, individuals, amazingly, if they feel invested in the system, they're much more engaged, especially when you reach out to them with the information for pretrial type diversion and other programs. I myself and a late friend of mine who was a law enforcement officer, we developed a program called the Conditional Discharge Program in Muskogee County, and it was required that these individuals could get out on a lower bond as long as they participated in this program. And we found that our recidivism rates were of the groups that we were dealing with was somewhere at the peak around 11%. But we had gotten it down into the single digits because the individuals felt they were invested in the program and that they weren't being asked to post extreme bonds, but at the same time they weren't just turned around and said, go free and we'll catch you. Because as you know, most individuals that end up in the criminal justice system initially, they don't see a judge for a long time. They many times, if they're using a public defender or even a paid attorney, the attorneys understand the slow movement of the criminal justice system. So at some point, they become somewhat disengaged. And we feel that this is a way to keep them more engaged in the system.
Thank you. Representative Byrd?
Thank you very much.
Yes, ma'am.
This room hears it quite often that I'm probably one of the few that is not an attorney. So
you and me. Yes, ma'am.
I know what a bail bondsman is, for sure. So am I correct in understanding that you are adding all of this new laundry list of things, crimes, that will have to be, you will have to get a bail bondman up?
Or, you don't necessarily have to have a bail bondsman. You can post the bond yourself.
Okay.
Yes,
but
ma'am.
So, and if they cannot, they would sit in jail for these types of things until someone could get them out. Is that correct?
Yes, ma'am, they could.
So going back to Representative Miller's point, I mean, certainly in Cherokee County, we've just built a brand new jail. It's quite nice, actually. But I mean, I think it's already at capacity.
Build it and they will come.
Absolutely. So I'm just wondering how they're going to handle all of these new people that are going to be sitting there and waiting for a bondsman or to bail themselves out. So,
well, and
thank you.
Again, yes, ma'am. And Ms. Byrd, I appreciate that. Representative Byrd, I apologize. Thank you. Was that a question?
No.
Oh, okay. Yes,
yeah,
ma'am.
I think you answered my question.
Yes, ma'am. I apologize.
I actually have a few questions, and I'll just go through a few.
Yes, ma'am.
So line 158, that's the recidivist code section. To my knowledge, GCIC doesn't necessarily show whether or not somebody has been sentenced under that code section as a recidivist. And so,
I apologize, Madam Chair. You say sentenced as a recidivist or as a repeat offender or multiple
correct.
charges?
Correct.
Yes, ma'am.
So, and the way that I read that section, that code, that F, section F,
Yes,
starting
ma'am.
with line 158, that they're not eligible for unsecured judicial release if they've been convicted under that code section. And I do not believe GCIC or the criminal history actually will notate that. So can you?
Are you on 158?
I am.
Yes, ma'am.
Okay.
It says, okay. Let's see something.
And that code section 17-10-7, that's
Yes,
the
ma'am.
repeat offender code section.
Right. I do know that in GCIC and in NCIC, sometimes looking at criminal history, you do see multiple arrests and adjudications of those arrests, whether it was, sentenced to Georgia Department of Corrections or whether the sentence was served locally, and sometimes based on the information in the system, you can see if they have been arrested and the case has not been adjudicated. So that's my understanding about. I'll be more than happy to go back and
Okay.
research to answer that question, ma'am.
Thank you. Because the way I read it is if somebody has been specifically sentenced to that, just because you are sentenced multiple times doesn't the prosecutor can prosecute under that specific code section. And so if not, just because you have multiple convictions doesn't necessarily mean that they were sentenced under this code section.
Yes, ma'am.
So I think that may be something to look into.
Absolutely.
And then line 255, and I highlighted and I did actually go through this entire bill just to get a better understanding.
I love the exercise.
You
You said 255?
Line 255.
Yes, ma'am.
So the judge shall, at the end of the court day. So can you just explain what you meant by that end of
yes,
that
ma'am.
specific day of court, or?
Yes, ma'am. What it is, and is as I think, with rare exception, I don't want to assume that Representative Byrd has been in the courtroom before, even though she's not an attorney. But
Just said it's nice.
But what we know is in the courtroom, when an individual fails to appear, the judge in many cases will forfeit the bond from the bench. And what we worked with the court on this, and then if you look down, that the bond is forfeited that day. But if you look on line 258, you'll see that the bench warrant for failure to appear. At the beginning, the way the legislation was written, the judge would forfeit the bond that day, and the bench warrant would be issued that day. Well, as we all know in the courtrooms, with the size of dockets and with the responsibilities of those who sit on the bench, that would be just overwhelming in some jurisdictions. So what we did was the judge will issue the forfeit of the bond for the individual failing to appear, and then within 3 business days, the bond will be issued for the failure to appear. And what that does is it relieves whoever has the bond out, they're relieved of the liability on the appearance bond.
Okay, and I think you mentioned it, and I was just concerned with kind of tying the judge's hands as far as getting, because oftentimes, when somebody fails to appear, there are definitely defendants that fail to appear on purpose, but there are definitely defendants that may not have received proper notice. Maybe their attorney had retained an attorney, and the attorney failed to file an entry and notify the court. There are definitely several things that can happen. So I don't want to make it where, and some judges, they start court at 9 o'clock and they're done by 10 o'clock. And they don't have time to kind of look into why this person may have failed to appear. And I know I've had, appeared before a judge on these cases, and, oftentimes we would have to show whether or not the clerk actually sent the right notice and gather that kind of information as well. So that was just kind of a concern that I had, especially with courtrooms that are very, very busy as well. So,
and that's right. And these would be individuals who had already been in the system and had posted. And so the failure to appear would lead to the forfeit of that. And so having, I guess, the last 8 years of my career, having Title 17 on my desk because of the responsibilities of, I guess at one time, I think it was 10 bonding companies operating within Muskogee County, that we realized we had to. It just, when you run into the FIFAs and everything else associated with it, you want the system to try to be as smooth and as quick as possible in order to get that. And we do understand the excuses and reasons why individuals could not. And what we witnessed a lot of time is in your case that you mentioned, where the attorney is there and the defendant's not, then a lot of times the judge reschedules and there is no offense because there's a reasonable chance that the individual was not notified. And many times if the clerk in the court could not show that they were notified, then the case was continued based on the schedule of the attorney in many cases. And when the next particular trial docket rolled up, and like in Fulton County and other places, we were a 6-day a week court. It wasn't, some of our more rural parts of the state where, court may be once a month or grand jury meets by, quarterly. It was pretty much rock and roll, Monday through Saturday.
And one more thing, Section 2, I think it starts with line 39.
Yes, ma'am.
I know that section relates to acceptance of bail in misdemeanor case. So line 43, in all other misdemeanor cases. And so
okay,
is
this existing law that we're...
No, so
Okay.
what I'm trying to point out is I know 43 relates to all other misdemeanor cases, but
Yes, ma'am.
in your bill, you had specifically taken out the wording felony offensive and the wording misdemeanor offensive and added other criminal charges. And so and this is just me trying to interpret it and read it correctly.
And I'm sorry, Madam Chair, I'm not following. Are we on 43 or 140?
43.
Okay.
Yeah.
Where's-
Section 243, where it says in all other misdemeanor cases. So I would.
Oh,
would
yes,
you-
ma'am, in
Would
all
you be
other.
reading it as that section would relate to misdemeanor cases that are not specifically listed on Section 3? And is there a reason why you guys you struck a felony offensive and a misdemeanor offensive?
And
Those
Can
lines.
you show me where that's struck?
Sorry.
I see reasonable.
Yeah,
struck in all.
line 66.
Oh, okay, I'm sorry.
And line 89. And this is just clarification. I was just trying to read the bill and.
I think the reason I think the reason Ledge Council would have struck a felony offense is I think it's that we all know that. Well, first of all, it moves that B. It moves the B and the C, and is dealing with legislative council in many cases. They will say if it is a felony, it does not have to be identified as a felony. In other words, if we know ag assault is a felony, then you don't have to put ag assault is a felony, because if you go to the code section on ag assault, it identifies it as a felony. Because looking at this right now, my initial assumption when I first looked at it would have been that because of the moving of the document, as you see the different lettering along there, I was assuming it was dropped down at another level, but they may be using the logic of the fact that aggravated assault is listed in Title 16. Therefore, if you read aggravated assault in Title 16, it is a felony.
Just one more question.
Yes,
So
ma'am.
on that note,
Yes, ma'am.
previously we had it where, and I'm looking at line 84
Yes, ma'am.
regarding DUIs.
Yes, ma'am.
So previously we had the felony offensive DUI as being related to this section. Now we would, reading your bill, it would be a DUI, misdemeanor, and felonies all included. Is that correct?
It would be, and Madam Chair, that's intentional because of the dangers of DUI. And I know that the committee knows that the road deaths and deaths as resulting of crashes are up in Georgia. We're in the country, we're probably, I believe we're in the top 5 now when it comes to automobile deaths. And a lot of times DUI is looked at in a way that I don't look at it, because I feel it is a serious violation of public safety, having individuals on the road. And there have been instances in the past where when the jails were crowded and we were allowing DUIs to come to jail, be processed, and then allowing them to go out after they adhered to the responsibilities of the implied consent law, that some of them were going back, getting in the vehicle and going back on the road. And we've had crashes as a result of that and other things. So DUI is one of those unique misdemeanors that I think is extremely dangerous to look at as a non-threatening misdemeanor.
Thank you. Representative Miller?
Yes, on the top, thank you, Madam Chair. On the topic of misdemeanors, I just want to make sure I'm reading this correctly because I might not be. Lines 43 through 48, we are now saying that every misdemeanor offense would require a secured bond. So you cannot get a signature bond for any misdemeanor in the state of Georgia. Am I reading that accurately?
If I just glance at it right now, it would seem that I'll research. I'll pull 17 out and look at that to make sure that we're tracking.
Okay.
Yes, ma'am.
Thank you. And then one other follow-up question on Section 10.
Yes, ma'am.
So Section 10, so as I was looking at the proposed change in your bill,
yes, ma'am.
What came to mind is one of these things is not like the other.
Okay.
And so I guess I'm wondering what the rationale would be. All of these 7 deadlies essentially involve significant bodily injury to a person. I don't think we have any 7 deadlies that relate to property damage. And I guess I'm wondering why we would add domestic terrorism to the exclusion of, let's say, human trafficking or, aggravated assault with intent to rape or enticing a minor for indecent purposes. What is the rationale for elevating this charge above other charges that have been excluded from this subsection?
I think what we have discovered in this country, and I think I've realized that, and I know you operate in a particular arena that gives you an advanced understanding within the criminal justice system, and as I did myself, that domestic terrorism is and has been for many years an extremely dangerous area. That domestic terrorism goes beyond just property damage. We can go back and discuss individuals such as Ted Kaczynski. We can talk about recent things here within the city of Atlanta where a group of eco-terrorists, and if you go out and look at the damage done where the new training centers go in, and you know the history of eco-terrorists, and you go back to the monkey wrenching and planning out of terrorism from the late 60s moving forward in the northwestern United States, coming on through with the environmental terrorists. When you look at the terrorism of other groups that came out of the 60s, when you look at the terrorism of certain hate groups, when you look at the terrorism that occurred in our capital just a few years back, I think what you realize in the defined code of domestic terrorism was actually put in there by Senator and Chairman Calzert, I think maybe 6 years ago. May have been prior to me coming into the Senate, or it may have been my freshman year. But that domestic terrorism goes well beyond just property damage, that there are many times injuries and even deaths attributed to domestic terrorism. And so I felt that without a doubt domestic terrorism should be there. And in recent cases here in Fulton County, where it seems like in some cases it's the same individuals, local individuals that were involved during many of the instances from 2020 forward, but that the fact that they are now certain groups are bringing in and recruiting individuals, professional individuals from outside of the state of Georgia and even outside the United States to come in here and carry out these acts of terrorism, that this is not just some kid throwing a rock through a window, that this puts our citizens in dire straits, and it should be considered a serious crime. And I do appreciate the reference to the 7 deadlies, and I know, but if you'll recall, at one time, auto theft was part of that too. Back when the FBI first classified those, because the owning of an automobile was a very rare thing, and so when somebody was steal it was a very serious offense. And so this list has evolved through times, thank goodness. But I think domestic terrorism sits well in that list.
I understand. Thank you. And
Thank
just
you, ma'am.
just for one point of clarification, then
Yes,
I'm
ma'am.
done. You can commit the offense of domestic terrorism by only doing damage to property, correct?
If based on motive, yes, ma'am.
Okay, thank you.
Yes, ma'am.
Any other questions? All right, we have several people signed up to speak, and I'll give them a little bit of time. First up is Gactel. I don't know who's here with Gactel. Amazing. Sorry, I couldn't see through the poll there.
Better be off camera. Long meetings. Thank you for hearing from us today, Madam Chairman. My name is Maisie Lynn Gerton. I'm the Executive Director of Gactel, and I'm joined by Titus Nichols, who is a practitioner, currently a criminal defense lawyer, but like Representative Miller, has a background as a prosecutor as well out of Augusta. I'm going to start back where the conversation has ended, and that's at Section 10 on the last page of the bill. Although we share Representative Miller's concern about the distinct difference between domestic terrorism and the other crimes outlined here, there's a bigger problem for you here, and it's constitutional. The list of crimes that are set out in 1710 6.1 that are here in lines 385 through 394 are here because of a constitutional provision allowing it. You find the constitutional provision in the Georgia Constitution under Article 4, Section 2, Paragraph 2, B3. In that, and I'm going to say the wrong word, subparagraph, it allowed that the General Assembly could approve the imposition of a life without parole sentence for people convicted of, and then it lists out these exact crimes: murder, armed robbery, kidnapping, rape, aggravated child molestation, aggravated sodomy, aggravated sexual battery. And that's where the list ends. It does also include what language we see in a lot of our code sections if they've been previously convicted under the laws of another state that would match these crimes. In those cases, you can also issue a sentence of life without parole. And why this is important is because the only way to modify this list in 1710 6.1 is to modify the Constitution. Because when you go to Code Section 1710.7, which is the code section that allows for life without parole to be a sentence for a recidivist offender of a serious violent felony, it refers back to 1710 6.1. So if you expand this list, you're effectively expanding the list of crimes that are subject to 1710.7, and 1710.7 exists solely because of the constitutional provision that outlines the specific crimes that are available for a life without parole punishment. So at a minimum, we believe that section of the bill needs to be removed unless you would like to also put forth a ballot measure on this issue. Returning to some of the other parts of the bill, Senate Bill 63 continues to perpetuate two criminal legal systems in Georgia, and it's been touched on a bit today. One for those who can afford bond and one for those who cannot. We know that our criminal legal system already disproportionately impacts the poor. Sometimes it could be the difference between having $15 or not having $15, as we've heard today. The reality of leaving people to languish in jail means they will lose their homes, their jobs, their in some cases, their children. This is all at an increased cost to the state because we will have to continue to house in our jails people who simply can't afford bond for crimes that have been discussed today, misdemeanor crimes that are not violent. For instance, one of the additions is criminal trespass. I know that in the Senate hearing on this bill, there was discussion about how a criminal trespass charge often comes along with a more serious charge, and that may well be the case. But there are certainly people who get ticketed only for criminal trespass, and they will be subject to this as well. Those criminal trespass charges that come along with a more serious charge are likely covered by the more serious charges that have been in this code section for quite some time, since Senator Robertson began his work in bond reform. And there was a little bit of question about the removal of a felony offense at line 66 and a misdemeanor offense at line 89, and I just do want to say clearly that the removal of those caveats does exactly what you all discussed. It means that misdemeanor offenses of pimping, of bail jumping, of DUI, of stalking, of criminal trespass, of misdemeanor marijuana possession, of simple battery, all will now be subject to the provisions laid here and require secured release. I also would like to draw your attention to lines 30 through 33. In this provision, this is a carve out saying that unsecured judicial release will be available for people who violate or are alleged to have violated 3.323.1, or if they have, if they're charged under a provision that does not require confinement. That second part would be something like a seatbelt violation, right? We're gonna allow unsecured judicial release for someone who has a seatbelt violation. No big deal, right? 3.323.1 is furnishing alcohol to minors. I don't know why we would want to carve that out when we're not carving out things like criminal trespass. But there are certainly some race and class discussions we could have in that space that I won't go into here, but I believe that we could. You all discussed at line 122 the idea of the second or subsequent offense of failure to appear. And unfortunately, what has been described as this necessitating someone having come before the court on more than one offense is simply not true. You could potentially rack up more than one failure to appear in a single case, especially if you don't get good notice, especially if the clerk has your address wrong. You could potentially end up failing to appear several times through really no fault of your own, and then be subject to this later, because what we heard earlier today and what you've heard now for 2 legislative sessions is that our court records are full of errors, riddled with them. And the idea that failure to appears are any different than the rest of that data is unreasonable. And until that exchange, I can't remember if it's called a task force, that Pete Scandalax is running, can get a hold on it, it's troublesome to us, just like it was in Senate Bill 44, that you are going to continue to rely on that bad data when you're making decisions about whether someone can be released on bail. I wanted to draw attention to one other code section that's implicated in this bail-restricted list, and that's a fray. And we do see a fray, I realize, is arguably violent. It is fighting, but it is also the charge most often used when children are involved in fights together. We often see adults charged more seriously, like with aggravated assault, when they are in fights, because a hand is considered a deadly weapon in those scenarios. But one of the ways the system is somewhat kinder to children is charging them with a fray instead of with aggravated assault when they are caught fighting, for instance, at school. It's already been mentioned how requiring court appearances on so many of these low-level nonviolent crimes will further cripple our criminal legal system, not just in Fulton County. Our entire system is impacted across the state. Mr. Nichols has some examples for you all, too, of how this will be impacted by the different terms of court that we have throughout our state.
The fact we all don't, not all the courts in Georgia operate on the same schedule. So if you get arrested for a misdemeanor that's on this list in, say, a smaller county like Liberty County, you're going to be sitting in jail much longer than if you were in a metro Atlanta county. And so, as already been stated, this bill is going to negatively affect the poor and those who just don't have the financial resources, who don't have a credit card, who don't have a relative they can borrow money from. They're going to sit until the judge, who is being shared amongst multiple counties, is able to come to that court to hear their misdemeanor. The fact that you can be denied bond because you missed traffic court, that's what's going to happen with this bill. Because I can't tell you the number of times I've had clients that I get a phone call that so-and-so has missed court because the clerk didn't have the correct address, or whatever administrative paperwork snafu happened, they missed court. But according to the statute, they would be put in jail and denied bond until they go in front of a judge. This also places a burden on taxpayers. I live in Cobb County, and I know from hearing the sheriff speak many times that it costs taxpayers to the tune of $100 a day to house somebody in the jail. So now as a taxpayer, I have to pay $100 per day to house somebody because of possession of marijuana or criminal trespass, regardless of what the circumstances were and regardless of whether that person is actual threat. I do not believe that it is, from my experience as both a prosecutor and as a regular attorney, I don't think it's reasonable to think that putting a financial telling someone to pay $15, that's going to be the deciding factor as to whether they come back to court or not. There is a reason why judges are allowed to use their discretion to determine whether someone is entitled to a signature bond or whether they should pay money. This bill takes that discretion away, and as I said, it increases the burden on taxpayers who now have to pay to feed and house people for missing traffic court.
I mean, I know some of my other colleagues in this space have more to say to you, and I don't want to steal their thunder or take up more of your time than we need to, but the extreme breadth that this bill brings to bail restricted, adding to the list of bail restricted offenses is of great concern to us. There are many crimes on this new list. There are things that we are mad about. Forgery. I had a classmate in law school, unfortunately made a really bad call and wrote a bad check at the farmer's market over in DeKalb County for some food that he didn't actually purchase. Yeah, obviously he didn't, but we tried to purchase, he wrote a bad check. What I know from working in DeKalb County as a public defender is that company doesn't charge writing a bad check, they charge forgery on those cases. So, I mean, not that I expect you to have sympathy for my law school classmate necessarily, but we're talking about some very low-level nonviolent crimes that have been added to this list, and really not the kinds of crimes that harm people like the list that was originally established. One other piece of concern, kind of from a technical legal nerd space, like I started the day, might as well end at the same place, is in section 2. At line 44, I was hoping that potentially legal counsel would still be here when we spoke, because this change from reasonable to sufficient is of concern to us. When we litigate the word reasonable, there's a lot that we can rely on in case law. We have an understanding, it's a term of art often, when we use reasonable in handling case litigation. Sufficient is a different matter. And so that this idea that we're going to start measuring using vernacular that's not as well litigated and potentially more subjective is just a concern to us in that space. We will certainly stand for any questions, but know that the hour is late and you've a lot of people to hear from.
We do have one question, Chairman Leverett.
Okay.
One question, this one sort of hits home with me, I guess, but so if I have a speeding ticket or something like that and I fail to appear, even if it's an innocent mistake, they generally are going to issue a bench warrant until I'm able to get in front of them and give sufficient excuse to get it released.
Failure to appears are issued on traffic offenses. Interestingly, you might remember when you all passed Senate Bill 44 the other day, the governor actually excluded non-serious traffic offense FTAs from his bond preclusions because we know it is unfortunately very prevalent and it's certainly easy for it to happen in that space.
But if I get subsequently stopped again, not that I speed that often, just for the record, but if I were to get stopped again and they've got that failure to appear, they're going to take me to jail at that point, aren't they?
A second failure to appear means you would not be released without security being put forward under this.
But I mean, currently right now, I thought that was generally what they would do.
Yes, if you have a bench warrant, yes,
Yeah.
you'll be taken in.
I'll take, and then I would need to do something to, either satisfy somebody that I'm worth the risk, I can get an OR bond, or I would have to come up with some kind of security or property or something, wouldn't I?
Right.
Okay, thank you.
Thank you.
Certainly.
Thank you.
Ben Lindy with ACLU. Line.
Good afternoon. My name is Ben Lind. I'm policy counsel with the ACLU of Georgia. I don't think I've had the privilege of being in front of this subcommittee before, but by way of background, I'm a former prosecutor, defense attorney, as well as a Senate research analyst before I started working for the ACLU. I'm here to speak in opposition of SB 63. While at the ACLU of Georgia, we're not in opposition to reasonable bail conditions. We are opposed to this bill because we believe it unfairly targets Georgia's poor, erodes due process by undermining the legitimacy of the criminal legal system, and makes Georgia less safe by increasing recidivism. And I'm going to turn to these points in turn. Largely the data I'm citing, and I can make this available to members, is from the 2018 report from the Georgia Council on Criminal Justice Reform, a years-long process that included stakeholders such as DAs and judges. This bill unfairly targets Georgia's poor, who are more likely to become justice involved already. At the point in which bond is being considered, I think this is important to remember, that a judge has already determined that a defendant is not a significant risk to a failure to appear or a threat to the community. It's just about finding a bond amount that is reasonable that the defendant will be considering their financial position for them to return to court. Given that at least 85% of criminal defendants are legally indigent, the only reasonable amount of bond for many, and this was my experience in practice, both as a prosecutor and defense attorney, it would be an unsecured judicial release. And I think that this bill would unintentionally erode due process as the Council on Criminal Justice Reform, and again in that 2018 report, found that leaving individuals incarcerated pretrial caused defendants to plead guilty at higher rates and harsher sentences. And we believe that this undermines the criminal legal system because we should not be promoting a system in which a person's wealth determines their culpability. And finally, we feel that this bill makes Georgia less safe. Again, going to the council's report, they found that individuals that were held for 2 or 3 days were more than 40% more likely to reoffend than those who were released on the same day. I think this goes directly to some of the language that's in Section 1 regarding misdemeanors and ordinance violations. The council found that the longer that the defendants were held pretrial, the more likely they were to reoffend. And finally, given I'm a grandson of an elected sheriff, I think it's worth noting the substantial cost of two sheriffs of detaining defendants pretrial, especially when we're talking about misdemeanors or alleged people alleged to have committed misdemeanors, nonviolent property crimes, which are normally considered crimes of poverty, and the people who would be most likely to need a UJR to not be held pretrial. I think that this was a major impetus in why the Council on Criminal Justice Reform was started, was this cost to sheriffs, and I think that it's something that we would have to address again if this bill was to pass. We understand the concerns that went into this bill, but we think that this body should consider the evidence-based practices to reduce crime and enhance personal liberty instead. I believe that many of Senator Robertson's concerns about tracking defendants are correct. People should be returning to court, but they could be amplified greater by eliminating cash bond entirely in lieu of a rigorous pretrial service system. And if any members are interested in having those conversations, we're happy to enable that. And with that, I'll yield and stand for any questions.
Great, thank you. I had a question, but I'm going to let Representative Miller go first. Go ahead.
Thank you, Madam Chair. I appreciate that. Thank you for your testimony. A couple questions. You may or may not be aware, and I may have this wrong, but did the ACLU issue a report on the conditions of the Fulton County Jail?
Yes, humbly, I'm a co-author of that report.
Okay. Can you just share with the members of this committee some of the concerns that were raised in that report, specifically as it relates to overcrowding?
Yes, and the purpose of that report was to identify systemic failures that largely spawned by COVID, we believe, that led to people being held pre-trial in the Fulton County Jail, and go back to the verbiage at the time and the concerns about people sleeping on the floor. So we tried to see who those people were. And using the sheriff's own data, we were able to identify, and I'm sorry that I don't have the numbers in front of me, but many people who were charged only with misdemeanors who had been held for significant periods of time, as well as individuals who had been waiting longer than the 90 days as required by Georgia law for them to have had their cases presented to a grand jury before they were released. That was specifically problematic, and I think really germane to this issue here, in the sense that at that point in time, those defendants should have been entitled to a reasonable bond that took into account their financial considerations and should no longer be held. While it's not a requirement of the statute that they be released following the 90 days, it is a requirement for bond to be given, and that for their financial situation to be considered and when granting bond. And so we feel that if it wasn't a bond that they could make, that could potentially be an equal protection violation. And we feel that this is the same way for many of the people who would be entitled to bond that are going to be held at least under Section 1 for potentially several days before they can be released. And then for individuals who are charged with felony offenses, being held for theft offenses or identity theft, or some things that we see are crimes of poverty, not being able to get an unsecured judicial release would equally be problematic for equal protection standpoint. I know my first, in going back to Senator Robertson, my first posting as a public defender was down in Meriwether County, Georgia. And hearing a lot of these cases come up and just getting calls from the sheriff being like, hey, can you talk to the DA to get us an OR bond on this case? I will waive, the $20 paperwork fee just to reduce their jail populations. We think that these are problems that are going to be exacerbated if this bill was able to go forward.
And in terms of the problems you just mentioned, the effects, the disparate effects that this would have on poor people, this could potentially also disparately impact the mentally ill, who are part of the homeless population, who we see oftentimes getting arrested for things like criminal trespass. Is that accurate?
Yes, the criminal trespass is one that I specifically see as being problematic. Again, so my time as a solicitor, my time as a prosecutor was as a solicitor in Cherokee County, which doesn't have a high homeless people experiencing homelessness issue. However, for those that who were experiencing homelessness that I did encounter as a prosecutor, criminal trespass was often the charge that they had at that point in time.
And specifically as it relates to Fulton County and how this change would affect Fulton County, the biggest, busiest county in the state, our jails right now are replete with violence committed against inmates by other inmates due to overcrowding, violence committed against staff at the jail due to overcrowding and a lack of resources. Do you believe those concerns for deputy sheriffs and jail detention officers would be exacerbated if the already overburdened system is required to now shuffle through affrays and forgeries and criminal trespasses? Do you feel like that those things would be exacerbated as well?
And not to speak for any elected sheriff, but I can look at the population trends as they exist today. And I also know how often, at least in my experience and practice, how quickly generally people on theft offenses or these other kind of offenses are released, or there's this diligence to get them out of jail. And if that requires an OR bond, that's what they're going to do. That the only reasonable expectation is that jail populations are going to increase. It is an issue that custodians are going to have to deal with.
Thank you.
Thank you. In my practice and in my experience, the list that we have here, most judges do set bond on these criminal charges. So, and I don't know, I don't expect you to have statistics unless you do. How often do you see judges issuing OR or signature bonds on these specific criminal charges that we're adding?
I can only go to my experience in practice. And so in my experience in practice, if it was an individual on a nonviolent, and this specifically from my time in the Cayuga Judicial Circuit, if it was a person at first appearance, that was usually a month after they have gotten arrested when they were going to have their first appearance hearing. If there were a person that was in on a nonviolent property offense and they had been in for a month, that was a demonstration that the bond that had been set, or the preliminary hearing would be a month later. Their first appearance. I'm sorry, that's a big issue. I'm not trying to confuse the committee more than I confuse myself. So their bond that was set at first appearance, if that was obviously something that they couldn't make because they sat for 30 days, waiting for their preliminary hearing, and it was regular practice for an OR bond to be set at that point in time on those cases. Other offenses that might be a little bit more up the level, when you start to get into, burglary and that kind of stuff, if bond was set, it might take longer. But I saw judges, increasingly unwilling to, keep somebody in custody, just even when bond had been set. If bond had been set originally, eventually they would resort to an OR bond. If a person had been sitting, waiting for their case to come to trial, which could take years, and so that was something that I saw.
Okay, and so on those smaller cases, how often do you see a judge setting OR bonds versus a prosecutor giving an offer to let him out and do time served and be done with the case?
That was more typical, just something I saw for like in jail call in state court cases when I was an assistant solicitor. In felony cases, it wasn't. That
So
wasn't my
when
experience.
I said, smaller cases,
yeah.
correct.
So
Okay.
yeah.
Okay, any other questions?
Research.
Sure.
We heard Senator Robertson talk about research that he had compiled as it relates to FTAs, and that you see more FTAs on cases where people are not required to pay a cash bond or have a surety. Is the ACLU aware of any research that supports that? Have you seen that research? Are you familiar with it? And can you just talk to us about that a little bit?
And it may be an oversight in my part and, the way we've been looking at things, but that's not research that I'm familiar with. But, it is something that when he said it, I would be happy to talk to him later in the hallway is maybe something that we can address in other ways. But I'm not familiar with that research, no.
Chairman Smith?
Thank you, Madam Chair. Question real quick. As far as misdemeanors and the economic effect it has on people that are locked up on a misdemeanor, and let's say, you lose your job because you can't pay your bond amount, do we have any kind of data on that?
So the best data that I can point to in that regard is specifically stuff that they looked at when I say the Council on Criminal Justice Reform. I would like to provide a few statistics that they provided regarding cash bail. And so they didn't look specifically at what those causes were because that's obviously pretty discrete and would probably be harder to look into. But what they were found, and I'm just going to read, defendants held in jail for 2 or 3 days after arrest were 39% more likely to be arrested on a new charge while the first case was pending than people who were released on the first day. Those jailed for 4 to 7 days were more than 50% more likely to be arrested for new criminal activity than those released on the first day. Those incarcerated for 4 to 7 days were 35% more likely to commit a new crime within 2 years of their prior adjudication than those released on the day of arrest. So that's stuff that we can look at. Those are data points and talks about the effects that it has on individuals, if they aren't, which specifically goes back to that increasing recidivism. But in terms of, I think that, we can all identify and understand, a person who, is held on an offense, how unlikely employers are to be maintain that employment for that individual if they can't bond out. And especially if we're talking about a person who's only waiting on a UJR to get out, you're probably talking about somebody who is in a wage earning, like a type of job that a person would feel, and employers may feel is more easily replaced. Like, well, I don't have to worry about with this guy because I can pick up somebody else for that kind of employment versus, someone, a professional managerial class individual. And I think that goes directly into when we're talking about the 2 tiers of justice, where in these cases of people waiting to do whatever they have to do to get out of jail are more willing to just take a plea to get out at their soonest opportunity to do so, regardless of what their actual culpability in the case, because they have to pay their rent or they have to maintain their employment or they have to support their families.
Chairman Leverett?
Thank you. Just a question. You may have addressed this. I apologize. My understanding is there is some, at least legal argument, or there's a case to be made, and I think y'all may have made it, that the imposition of cash bond in many circumstances is unconstitutional.
So when that was an observation without citation to authority in the Council on Criminal Justice Reform Commission. That is something that the ACLU hasn't directly addressed in any literature, and I don't think we're taking that position at that point in time. But I appreciate the question because it does allow me that was an observation of the council, but they did it without a citation to authority, so there's nowhere I can point you for that.
Okay, so I'm sure one could piece together an argument, but y'all haven't done so formally or through any litigation at this point.
That's correct.
Okay. So is it fair to say that to the extent you can speak for the ACLU, it is the ACLU's position that cash bonds in and of themselves are not unconstitutional? They might be unconstitutional as applied in certain circumstances given the financial condition of a particular defendant and the scope, and I suppose it would also take into consideration the nature of the crime with which that person is charged in sort of a totality of circumstances.
From a policy standpoint, I would say that more or less is my understanding, but I don't want to speak for our legal team who may have a different opinion.
Okay, all right. So you're not aware that the SOU has then actually staked out a position necessarily on that narrow
That's correct.
Okay, thank you.
Thank you. That's all the questions.
Thank you very much for the committee's time.
Thank you. Isabel Otero.
Hi, good afternoon. Thank you, Chair. My name is Isabel Otero. I am the Georgia Policy Director for the Southern Poverty Law Center Action Fund. And to just quickly address Representative Leverett, so courts have held that denying unsecured bail to indigent defendants does violate the U.S. Constitution, Equal Protection Clause. And so this bill will inevitably treat defendants who can pay or put up collateral differently than indigent defendants, and that immediately raises an equal protection concern. And so there are alternatives to bills like this. And we've talked to Whip Robertson a lot about failure to appear rates and how to deal with them. And our approach and what we're hoping to see more of is what the research shows, which is if you update court forms, if you make them easier for people to understand, if you help give people text messages about their court appearances, you're more likely to get a rise in failure, in less failure to appear rates than you are seeing now in Gwinnett County. Simply issuing a second written reminder improved appearance in court by 95%. And if we do these two very simple things overall, states like Texas and Colorado have done this statewide. Texas has many more counties than we do, and they've done this statewide and have reduced failure to appear rates by 36%. And so as you all have heard, there's a couple of things that I'm not sure have been mentioned that I wanted to flag, which is for the way that this bill is written, it could affect pretrial education or rehabilitation programs where it doesn't really address those things until well after the indictment phase of your case. And so you might be sitting in jail for a very long time when the option would have been or could have been pretrial diversion because you have now an unsecured or you're not allowed to get an unsecured bond. And so we wanted to flag that piece as well, and also just echo what my colleagues have said about pre-pandemic levels of jail populations. We're already back at the levels pre-pandemic, and the majority of those people are already awaiting trial. And so, this will only exacerbate that issue. And I won't continue to repeat what you all have heard. I know it's late in the day, but I just wanted to flag those few things. Thank you.
Chairman Leverett.
Just another quick question. I guess to Whip Robertson's, I'm assuming the concern that prompted him to produce this legislation, though, I think there's a concern that just as I think it's unfair to assume that everybody's going to skip, I think it's equally as foolish to think that nobody in the realm of accused individuals is going to skip. And I think given some of the problems we have had recently, while there may not be a causal connection, there certainly does seem to be a correlation between increased rates of crime and less than vigorous enforcement of cash bonds. So it is... I guess I'm trying to figure out what can we do to ensure appearance other than what is the more traditional method of giving someone some skin in the game and their appearance at their own trial.
Right, and so what we found through research and other things is that failure to appear rates are high, and it's not usually an intentional thing. So the majority of them won't be people who are just not wanting to show up, right? It's either it's an employment issue, it's a child care issue. There's many different reasons. It's an issue of just administrative snafus, like what was mentioned before, of just someone doesn't have their address or they didn't write Northwest on the street name, right? Like there's just several different issues that have come up that cause someone to fail to appear. And the reason, and many of the types of offenses that someone might fail to appear for shouldn't, I don't think, be under, restricted in this way. And so we're what we've seen that has been effective in several other states has been very simple things like your dentist reminding you that you've got your appointment. Courts doing that, that will decrease failure to appear rates. Like there are many different ways in which people, just a layperson, will not understand necessarily some of the next steps in their case and might not understand the consequence of showing up or not showing up. And so there's just different reasons that it's not always an intentional thing, and we're trying to address it through ways that won't just keep people in jail indefinitely and would allow them to still continue through their case.
Sure.
Well, and I appreciate that, but I mean, what about the guy who skips? What about the guy who's going to skip and takes off and does some bad stuff? What can be done? Because sending him a letter is not going to make him or her show up.
Right.
What sort of things can be done to provide some security that we're administering a system that is not only fair to the folks who don't have a lot of means, but that also ensures protection of the general public? I think that's the issue that Whip Robertson's I shouldn't speak for him, he's here, but I think that's a big concern, and that's a big reason for this bill, is to try to increase public safety.
Yeah, no, I mean, we understand.
You may not have that answer.
Right, I don't necessarily have the answer, and there are other folks that will come up after me, but I think there are, for someone who is a repeat failure to appear, like there are different mechanisms, right? And the judge and the prosecutor and other folks will take those things into consideration. I don't, what we're trying to prevent is more of these folks who there is a different reason for them to be failing to appear, right? We're more concerned about those folks than we might be the folks where there might be a different remedy for making sure that they do comply.
So I guess what would be fair to say, your concern is about a blanket rule of application. You're not necessarily
correct.
You don't necessarily object to failure to grant bond at all.
Correct. Right.
In some cases.
Right. Thank you.
Thank you. Caitlin Mully.
Good afternoon. Caitlin Malloy. I'm with the Southern Center for Human Rights. It's fine. It's a new last name for me, and still getting used to it. Southern Center for Human Rights, we are here in opposition to the bill today, and I will not repeat the things that have already been said, but I do want to answer some of the questions that have come up. So I want to start with the conversation that we were just having about the effect of cash bail, and in those cases where someone is going to skip, and what do we do there? There's no evidence that we have seen that cash bail makes it more likely that you will reappear. There is an idea that we all have, a conception that we all have, and that is the sort of intended purpose of cash bail, that is not borne out in the research. So cash bail will not make it more likely that the person who wants to skip won't do that. And I think where we landed in this conversation is it's about eliminating a judge's discretion to order cash bail or release someone on their own recognizance. A judge is going to look at someone who has multiple FTAs on their record, many past convictions on their record. A judge is going to look at that person and one would not even have to get to the place of ordering cash bail. They can deny bond entirely, right? They can decide that person is going to stay in jail pre-trial regardless of anything else, regardless of their ability to pay anything, right? That is well within a judge's discretion on any offense. So that is sort of, I think, just wanted to clarify that. Another question that came up had to do with the collateral consequences. Chairman Smith, you asked about this, the collateral consequences of pretrial detention, and what evidence we have about, when someone is being detained pretrial, what does that mean for their job and their families? There are lots of studies that show that those folks are more likely to lose their jobs. They are separated from their families. They are more likely to be convicted of the offense they are charged with and to face higher sentences because they are less able to assist in preparing the defense, in preparing their own defense than those folks who are released pretrial and able to work with keep their jobs, stay with their families, and assist in preparing for their defense. So those are, and at the end of the day, what cash bail does is put people into either of those categories, not based on whether those folks pose any risk to public safety, but whether they have access to money. It is purely about access to financial means to purchase your freedom, because again, the judge has already decided that this person is someone who is eligible for release pre-trial and eligible for release to the community pre-trial. So just wanted to kind of come back to that briefly. And then one more had to do with the question about FTAs and where what kinds of offenses we're seeing that FTAs are most common, right? I'm not aware of any Georgia-specific study or data with regard to that, but I know that there have been studies of other jurisdictions sort of nationally and it's generally accepted that a person is less likely to fail to appear for subsequent court proceedings for felony offenses because they know that they are facing harsher consequences, right? That they are taking that more seriously. They are more likely to show up when they are facing a felony charge than if they're facing a traffic violation that maybe they think they just have to pay the fine and they can move on, right? And so FTAs are more common for those lower level offenses, not for the higher level offenses. The last piece I wanted to add was just to come back to this conversation around domestic terrorism and something that has not been pointed out, and that is the effect of adding domestic terrorism to the list of serious violent felonies. If I agree with my colleagues and their interpretation that code section is not sort of constitutionally permissible, but really important to understand what it means to add that to this list. It means that a person cannot qualify for first offender treatment. It means that they can never have that record expunged or restricted, so that will always be visible on their record. And it means that if this is their second conviction of one of those offenses, they are mandated to spend life in prison without parole. So those are very serious consequences that are attached to very serious offenses, those 7 that are there now, and adding domestic terrorism, which it has mostly been charged in cases involving only property destruction, is a big concern to us. So that's all I had.
Thank you.
Thank
We
you.
don't have any questions. Thank you. And Judge Eddie Barker. Thank you, Judge, for your time.
Thank you. Good afternoon. Members of the committee, thank you for allowing me to be here with you today. My name is Eddie Barker. I'm the Chief Judge of the State Court in Douglas County. You've already heard from our District Attorney, Ms. Racine, who is doing a fabulous job, I would point out. And I'm here to speak to you, just offer some comments from the Council State Court Judge's perspective on Senate Bill 63. Not really taking a position of support or against it or anything. This is just, I wanted to talk about a couple of the concerns that we have, as well as some of the good things that we see as part of the legislation. I'll start with that. The bill does include a number of serious misdemeanors that do require bond, and of course, what is to be included and or excluded is certainly a decision that's within the purview of this branch of government, and we're going to follow along with whatever y'all decide. It does give us the ability to also incorporate unsecured judicial release where we feel it's appropriate. Of course, as you know, for judges, having some discretion in what we do is always very important to us. It appears from the intent of the legislation that it is aimed to require more people to make a bond, which is, when people get arrested, they go to jail and then they have to make that bond in most cases. And so if that is the intent of the legislature, then we do have a couple of concerns with that, because it seems that part of this legislation it appears to be making it easier to relieve the bail bonding companies from their responsibility and liability in assuring that defendants show up for their court appearances. And I'll give you an example. Madam Chair, you already talked earlier about Section 8, it's line 255 through 259, where you asked about the issuing of the bench warrant at the end of the day. I believe that was the language in the original bill, and I believe there was a modification in the Senate committee that changed that to, as it is now, 3 business days for the courts to actually enter the bench warrant. And I will just point out to you that the current law, which is at OCGA 17671, actually allows us 10 days before we have to issue the bench warrant. And my question is, why the need to do away with 7 days? Because those 10 days are very useful. As y'all know, all these courts are busy. State courts are very busy, not that superior courts and other courts aren't. But we see literally hundreds of people that come through each week in our courts. And having that additional time to handle those kinds of administrative matters is very useful. I will just point out a couple of examples. First of all, in our county, sometimes our clerk's office has difficulty getting appropriate notices out. That's been a problem for us for the last couple of years. And so our policy now is we don't, as judges, we don't sign any bench warrants until we have our judicial case manager go back and double check. And that takes time, especially when we have a traffic arraignment of 250 people and they're asking us for, 75 to 100 bench warrants on folks. So we don't want to issue a warrant unless we know it's justified. And so having that additional time gives us the opportunity to go through and make sure we're doing what we're supposed to be doing. The other part of that is, from our experience, having a bondsman, more people show up when they have a bondsman. They just do, because the bondsman has a financial motivation for the people to appear. And I heard the comment earlier about the courts calling and stuff like that. Well, and that may be very effective, but that's the bondsman's job, is to keep in touch with those defendants when they come to court and make sure that they're there when they're supposed to be there. Sometimes we have people that show up the next day, or they show up a couple of days later when they realize somebody they know has called them. I've had that happen. Somebody calls them and says, hey, they called your name in court a couple of days ago. They were there for their speeding ticket and they happened to hear a name and didn't see them. I've had that happen in people. So that's the reason why having that 10 days would be, I believe, more appropriate to leave and basically leave the law like it is, because it's 10 days for a reason. Finally, I would just point out, and it's at line 198 through through line 201, it's in section 4, where the law already currently allows, after the passage of 1 year, that in misdemeanor cases that the bondsman be relieved of liability at that time. Now, Georgia law for misdemeanors, for prosecution of a misdemeanor, is 2 years. And it's not uncommon for a solicitor to take several months up to a year, especially with the backlog from COVID that we're now dealing with, for them to take that period of time and even file an accusation. And then, of course, an arraignment has to be scheduled and then hit a trial counter. And it's almost never are we going to get a case, at least in our jurisdiction, to trial in under a year with the numbers that we have, despite our best efforts. We were fairly close pre-COVID to doing that. We were probably in the 18-month range, and now we're probably more like 2 years on the average. But the point being is that there is a already built-in mechanism in the law to allow bondsmen to be relieved of their liability if the case isn't moved in that period of time or resolved either with a trial or a plea or some other disposition. And the reason I point that out is because the statute and the bill proposes that if you miss a deadline, if we don't issue that bench warrant within that 10-day period, or if, as written, if it's 3, if the clerk and the solicitor's office don't send that bond forfeiture out notice appropriately and timely, and they miss that deadline, at that point in time, this statute would relieve the bondsman of all liability, which in effect is going to have the opposite effect of what I think the intent is, which is to have more people on a secured bond so that a bondsman's keeping up with them and monitoring them. This statute, as written, builds in that mechanism where the bondsman could do just the opposite and be relieved from their liability if some deadline is missed. And we of course we try not to miss deadlines, but it just happens in the course of a busy court system. And so that's our, my concern and our concerns as judges, my fellow judges, is that we, not make too many changes to this as far as what the deadlines are, and giving us the ability to do our business and make sure folks have appropriate notice and know when to come to court, so that we only issue bench warrants where they're appropriate. I'll be glad to answer any questions if you have any.
Sure. Thank you, Judge. Chairman Smith?
Thank you for taking time out of your busy schedule to come and see us. One question. We're really sensitive to concerns that y'all have from the bench, and this is a question to Senator, or to the Majority Whip from the Senate. Let me get my titles right. Would y'all be willing to work with the Majority Whip on this and seeing if there's some kind of path forward?
Absolutely.
And I think.
Chairman, this is a 2-year process.
Okay.
It's a 2-year process. On this piece of legislation right here, the hearing is what I wanted. So as we walk through this, I'm in no hurry to move this through. And I do want to say something that the judge said, or recognize something. I think when we talk about this, we talk about DAs and all this, but the one thing that we overlook, there is not a more heavier load lifted in this state than in state court. People don't appreciate the number of cases, and absolutely we'd love to sit down with them and have that conversation.
Okay, thank you.
Great. Thank you, Judge.
Thank you for having me.
And I think that ends all of our speakers and people who have signed up. Do we have any comments from the committee? Any discussion? Okay. It's going to be here. Yeah. All right. Whip Robertson, would you like to finish us out, say a few words? And go ahead.
Yes, ma'am. Madam Chair, I do want to say that it has been an absolute pleasure testifying in front of your committee today. While your overall chair is a pretty decent guy, I really appreciate the way you run a subcommittee. But but I do want to say this. I'm a father of 3 children, and these pieces of legislation are not my children. They're just laws and bills that we attempt. And the initial one I spoke about is extremely important to me, and I think it's timely. This one here is as I said before, this is a 2-year process, and I'm comfortable working through it. But real quickly, as far as research goes, I've researched this with every association that's done research, and the vast majority of research I have found is extremely biased based on who's doing the research. Mm-hmm. So what I've done, and is what most of us in this room do, is when I want to find out about overcrowded jails, I call the 159 sheriff's offices in the state. When I want to find out what's going on in prisons, Georgia's Department of Corrections does a great job in putting that information out. We're looking at real pulses and real heartbeats here in Georgia. So as we move through this process, any research that the subcommittee may want, may need, and anything that I can provide to back up, please let me know, because I'm more than happy to help. But thank you again for this pleasant experience. And whoever the overall chair is, I'm sure he appreciates the good job you do.
Good. Thank you. I appreciate that. And I appreciate that very much. And I will say, as somebody that does practice regularly in courtrooms, I think this is important as far as also kind of, talking to practitioners that do see this every day. I have clients that fail to appear even when they are retained by me. I have clients that don't. And, I have misdemeanor, felony clients and on all levels. And so I think we've discussed some of the concerns, and I think we can really work with everybody on this. So thank you for bringing it.
Thank you, ma'am.
Yeah, I appreciate it. And we will keep this as hearing only today.
Yes, ma'am. Thank you.
And with that, our subcommittee is adjourned. Thank y'all.